The Judiciary Committee will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time. I'll recognize myself and then the ranking member for an opening statement. Welcome Attorney General Holder to today's oversight hearing of the Department of Justice. Regrettably, the Obama administration has shown a disregard for the Constitution and rule of law in an effort to impose their agenda on the American people. And there are many examples. Efforts to block congressional inquiries about the administration's actions undermine the balance of power on which our nation is founded. The Department of Justice still has not provided enough information about Operation Fast and Furious so that the American public and Congress can judge who in the department bears responsibility for the decisions that led to Agent Brian Terry's death. The Justice Department refuses to comply with congressional subpoenas that may shed light on why this program was authorized and who had knowledge of the inappropriate tactics. The Department of Justice also has failed to provide relevant information that would have revealed the extent of Justice Kagan's involvement in the development of the Affordable Care Act when she was Solicitor General. If she did give counsel on the health care bill, which was her job, then she should recuse herself rather than evaluating the law as a member of the Supreme Court. The Justice Department has refused to let us interview her former assistants. Neglecting to enforce or defend the laws enacted by Congress is another violation of the administration's constitutional obligation to the American people. Under this president, the Justice Department has engaged in a pattern of selective enforcement of the law in order to advance its own partisan agenda. For instance, the Obama administration has sought to prevent state and local authorities from enforcing immigration laws. At the same time, the Justice Department has refused to bring cases against sanctuary cities that violate federal law by prohibiting their officials from communicating with the Department of Homeland Security about illegal immigrants they encounter. Such sanctuary cities directly challenge the federal government's authority to enforce immigration laws. The administration's unwillingness to uphold immigration laws has led to injuries and even death. The administration refuses to defend the Defense of Marriage Act, a law enacted by Congress and signed by then-President Bill Clinton. This was a significant piece of legislation that was approved by a vote of 342 to 67 in the House and 85 to 14 in the Senate. Regardless of how one feels about the substance of the bill, the Department of Justice has an obligation to defend the laws of the land. Efforts by the administration to override election laws enacted by states also raise constitutional concerns. Instead of acting to prevent voter fraud, the Department of Justice has challenged common-sense voter ID laws that require voters to identify themselves before they are allowed to vote. The Department of Justice recently moved to block implementation of voter ID laws enacted by legislatures in Texas and South Carolina. The Texas proposal was based on a similar law passed by the Indiana legislature, which was upheld by the Supreme Court in 2008. The Justice Department's challenge to the law ignores Supreme Court precedent that affirms a state's right to enact laws to protect the integrity of its elections. The Department of Justice even threatened to sue Florida for trying to remove ineligible non-citizens from its voter rolls. Why would the Department of Justice not want states to remove ineligible felons, ineligible non-citizens, and the dead from their voter rolls? The administration's actions aren't just wrong, they are arrogant, undemocratic, and an insult to the rule of law. The administration's disregard for the Constitution and rule of law not only undermines our democracy, it threatens our national security. The Justice Department has not taken the initiative to prosecute leaks of national security secrets. Recent leaks about a foiled bomb plot out of Yemen and a cyber attack against Iran are, in the words of Senate Intelligence Chairwoman Dianne Feinstein, quote, very detrimental, very concerning, and hurt our country, end quote. For the past 3.5 years, this administration has engaged in a pattern of obstructionism, unaccountability, and partisanship. The American people should have confidence that the Department of Justice fairly enforces laws. That confidence is lacking today. This hearing will explore how that confidence can be restored. That concludes my opening statement, and the gentleman from Michigan, the ranking member of the Judiciary Committee, is recognized for his.
Thank you, Chairman Smith, and welcome, Attorney General Holder. The opening statement is an opportunity for both of us here to set the tone for this hearing. But never in the career of Chairman Smith as the chair of this committee have I heard so many erroneous statements. And having never heard them before, I can assure him and you that I will be going over his statements and help him arrive at a more factual and impartial conclusion. Now, having said that, we welcome you once again to the House Judiciary Committee. This, by my count, is the 8th time this Congress that the Attorney General has made himself available for questioning. And this level of access is extraordinary, particularly when we compare your record to that of your immediate predecessors. Now, with respect to the continuing investigation into Operation Fast and Furious, I want to thank you for your patience and diligence. To date, the Department of Justice has provided over 7,600 pages of documents to the Congress. You made additional law enforcement sensitive materials available to us in dozens of briefings. You've permitted us to question senior department officials in hearing and in transcribed interviews. And you yourself have appeared before this committee once every 6 months since the controversy became public. I hope that the tone of today's discussion reflects the many courtesies that you and the Department of Justice have shown us in the past months. And I also want to commend you and the Department of Justice on a series of important accomplishments in the field of civil rights and voting rights. A couple of issues that I've paid special attention since I first became a member of the House Judiciary Committee. Enforcing Section 5 of the Voting Rights Act. The department has aggressively enforced Section 5, which ensures that states with a history of discrimination can't create additional barriers to minority access to the ballot box. The department has already blocked discriminatory voter IDs laws in Texas and South Carolina, and I would encourage you to look at other similar troubling laws taking effect across the country. Stopping illegal purges of the voting rolls. Last week, the voting section wrote to the state of Florida demanding that they cease and desist from purging voters from the rolls. The practice was not submitted to the department under Section 5 and would not have been approved if it had been. Protecting the rights of members of the armed service in terms of their voting. The department has secured court orders and consent decrees in 14 jurisdictions to better enforce the Military and Overseas Voter Empowerment Act move. Restoring the integrity of the Civil Rights Division. After the Office of the Inspector General and the Office of Professional Responsibility completed their review of illegal partisan hiring practices under another administration. Their final report included recommendations for improved, transparent hiring process at the Civil Rights Division itself. And under the leadership of Assistant Attorney General Tom Perez, the division has fully adopted each of those recommendations and is now predominantly staffed by attorneys with actual experience in the field of civil rights law. Enforcing the Fair Housing Act and the Equal Credit Opportunity Act, the department's $335 million settlement with Countrywide Financial last December compensated families who were charged higher fees and interest rates because of their race or national origin. This enforcement action makes clear the department will not hesitate to hold financial institutions accountable for lending discrimination. There are, of course, areas which we hope the department will improve. But today, 4 years after the worst economic upheaval since the Great Depression, we are still looking to hold some of those Wall Street barons accountable. And according to one, well, let me conclude. My time is ended, and I thank the chairman. And yet, what we want to do here today is have a thorough and fair discussion. And I'm going to ask that our colleagues on this committee conduct themselves in a manner that is worthy of the Attorney General's present appearance here. I thank the chair. I yield back the balance of my time.
Thank you, Mr. Conyers. Our only witness today is United States Attorney General Eric H. Holder, Jr. On February 3rd, 2009, Attorney General Holder was sworn in as the 82nd Attorney General of the United States. Attorney General Holder has enjoyed a long career in both the public and private sectors. First joining the Department of Justice through the Attorney General's Honors Program in 1976, he became one of the department's first attorneys to serve in the newly formed Public Integrity Section. He went on to serve as a judge of the Superior Court of the District of Columbia and the U.S. Attorney for the District of Columbia. In 1997, Mr. Holder was named by President Clinton to be the Deputy Attorney General. Prior to becoming Attorney General, Mr. Holder was a litigation partner at Covington & Burling LLP in Washington, D.C. Mr. Holder, a native of New York City, is a graduate of Columbia University and Columbia Law School. Mr. Holder, we appreciate your presence today. Look forward to your testimony, and please begin.
Well, good morning, Chairman Smith, Ranking Member Conyers, and distinguished members of this committee. I appreciate the chance to discuss some of the key accomplishments that have distinguished the department's work throughout this administration and to outline our plans to build upon this particular record of achievement. In particular, I'm proud of the work that's been done by the department's 116,000 employees, as well as our government and law enforcement partners worldwide, to help fulfill the promises that I made before this very same committee about 3 years ago. Shortly after I became Attorney General, I pledged to strengthen the department's efforts to protect the American people from terrorism and other national security threats, to ensure that every decision and every investigation and every prosecution would be guided by the facts, and by the law, and by nothing else. I also reaffirmed my commitment to move aggressively to prevent and to combat violent crime and financial fraud, to seek justice for victims, to protect the most vulnerable among us, to safeguard the environment, and to uphold the civil rights of all of our citizens. In each of these areas, the department has made tremendous, and I think in many cases, historic progress. Nowhere is this more evident than in our national security efforts. In the last 3 years, the department has secured convictions against scores of dangerous terrorists. We've identified and we have stopped multiple plots by foreign terrorist groups as well as homegrown extremists. And we have strengthened essential surveillance and intelligence gathering capabilities in a manner that is consistent with the rule of law and our most treasured values. Just last month, we secured our 7th conviction in our Article 3 civilian courts in one of the most serious terrorism cases that our nation has faced since 9/11, an al-Qaeda-sponsored plot to conduct coordinated suicide bomb attacks in the New York City subway system. And roughly 2 weeks ago, we obtained a guilty verdict in the case of a former member of the U.S. Army who intended to bomb U.S. soldiers in a restaurant in Killeen, Texas. On the same day, another Texas man was sentenced to 20 years in prison for attempting to become a part of al-Qaeda in the Arabian Peninsula. Now, in addition to our national security successes, the department has made meaningful, measurable strides in protecting Americans from violent crime. Through innovative programs such as our Defending Childhood Initiative and a National Forum on Youth Violence Prevention, we have developed comprehensive, collaborative approaches to addressing the causes and remedying the consequences of violence among and directed towards our nation's young people. By forging and strengthening partnerships between our United States Attorney's offices and federal, state, local, tribal, and international law enforcement officials, we are combating gun, gang, and drug-fueled violence more effectively than ever before. Alongside key law enforcement allies and our counterparts in Mexico and other countries, we have orchestrated a series of coordinated strikes against violent drug cartels, arresting thousands of cartel members and seizing billions of dollars in assets. We're also implementing strategic, desperately needed plans to address the shocking rates of violence that plague American Indian and Alaska Native women through tribal communities. And we are using every resource and tool at our disposal, including the power of research and scientific analysis, to protect our nation's law enforcement community, which in recent years has seen an unfortunate and totally unacceptable rise in the line of duty deaths. Now, many of you work to raise awareness about the tragic fact that violence against law enforcement officers is approaching the highest level that we have seen in nearly 2 decades. As Attorney General and as the brother of a retired police officer, I'm proud that the department has responded to this recent crisis with resolve and with robust action. Just last week, I met with the Major City Chiefs Police Association at its summer meeting to discuss the ways that we have developed and implemented a host of important programs such as the landmark Valor Initiative, which is providing our law enforcement partners with the latest in training tools and resources, as well as the Bulletproof Vest Partnership Program, which has helped more than 13,000 jurisdictions purchase life-saving bullet and stab-resistant equipment in order to help protect those who risk their lives to keep us safe. Put simply, our commitment to officer safety has never been stronger, and as recent achievements prove, the same can be said of our resolve to protect American consumers. Since the start of this administration, the Justice Department has signaled an unwavering commitment to preventing and combating a wide range of financial and healthcare fraud crimes. We have taken bold steps to address the contributing factors and consequences of the recent economic crisis, and this work is paying dividends. Last year alone, the Department's Consumer Protection Branch, working with U.S. Attorneys' offices across the country, attained a 95% conviction rate, secured more than $900 million in criminal and civil fines, restitution, and penalties, and obtained sentences totaling more than 130 years of confinement against more than 30 individuals. In cooperation with our partners at the Department of Housing and Urban Development and a bipartisan group of 49 state attorneys general, we achieved a $25 billion settlement with 5 of the nation's top mortgage servicers, the largest joint federal-state settlement in the history of the United States of America. Through the efforts of the President's Financial Fraud Enforcement Task Force, which was launched in 2009, we've obtained prison sentences up to 60 years in a variety of fraud cases, including multi-million-dollar Ponzi schemes and the largest hedge fund insider trading case in the history of this country. We have established 2 new working groups to enhance civil and criminal enforcement of consumer fraud and to bring federal and state authorities together in investigating and prosecuting misconduct by financial institutions in the organization, securitization, and servicing of mortgages that contributed to our financial crisis. And we've continued to make tremendous gains in our work to combat healthcare fraud. In fact, over the last fiscal year, in cooperation with the Department of Health and Human Services and my partner, Kathleen Sebelius, and by utilizing authorities provided under the False Claims Act and other essential statutes, we have recovered nearly $4.1 billion in cases involving fraud on federal health care programs. That is the highest amount ever recorded in a single year. And for every dollar that we have spent combating healthcare fraud, we have returned, on average, $7 to the U.S. Treasury, the Medicare Trust Fund, and others. The Department has also taken crucial steps forward in protecting the most vulnerable members of our society and ensuring the civil rights of all of our citizens. Over the past 3 years, our Civil Rights Division has filed more criminal civil rights cases than ever before, including record numbers of human trafficking cases, in an effort to ensure that in our workplaces and our military bases, in our housing and lending markets, in our schools and places of worship, in our immigrant communities, and in our voting booths, the rights of all Americans are protected. In addition, we're working to strengthen the rule of law across both the country and around the world and beyond our borders, establishing the global alliances necessary to combat transnational organized crime, as outlined in the President's strategy. This includes combating intellectual and financial property crimes, child pornography rings, organized criminal networks, and criminal facilitation of terrorist activities. And we've partnered effectively with members of Congress to advance important changes in policy and legislation, from landmark hate crimes legislation to the reduction of the unjust and unfair crack powder cocaine sentencing disparity. Now, this work goes on today in our efforts to help ensure the reauthorization of the Violence Against Women Act, a critical law that has transformed our nation's response to crimes against women and enhanced our ability to achieve justice for victims while holding offenders accountable. It goes on in our strong support for the renewal of essential authorities, such as those included in the Foreign Intelligence Surveillance Act amendments of 2008. And it endures in our determination to build upon the extraordinary accomplishments that have defined the past 3 years, to take our fight against terrorism, crime, fraud, and other threats to a new level. I'm proud of these and the Department's many other achievements, and I hope to spend most of our time today discussing how we are working to build on this progress. However, I'd like to briefly address the ongoing investigations into the ATF gun trafficking operations along the southwest border. As a result of concerns raised by ATF agents, we now know of several Arizona-based investigations that occurred under this administration and the previous one, where inappropriate tactics were used in an attempt to stem the flow of illegal guns across the southwest border. Although these law enforcement operations were focused on the laudable goal of dismantling illegal gun trafficking networks, they were flawed, both in concept and execution. Now, I share your concerns about how these operations were developed and how they were implemented, and that's why, just as congressional leaders have called for answers, I asked the Department's Inspector General to conduct a comprehensive investigation as well. I also put in place new leadership at ATF, which has taken steps, including the implementation of a stricter oversight procedure for all significant investigations to prohibit the flawed tactics employed in these operations. Now, many of the key enhancements implemented by the Department are set out in the Deputy Attorney General's letter to the committee that is dated January 27th of this year. Even since the date of that letter, however, we have continued to refine the Title III process. For example, our Office of Enforcement Operations now requires that before it even accepts a request for a wiretap intercept from a United States Attorney's Office, a supervisor in the relevant U.S. Attorney's Office must personally approve that request. Now, I would be remiss if I did not point out that the ATF agents who testified before Congress have also asked that law enforcement be provided with the tools that it needs to effectively combat gun trafficking on the southwest border. And I want to reiterate my commitment to working with congressional leaders to meet the needs of our law enforcement partners and to help address serious national security challenges on our borders. Finally, I want to make clear that we welcome the recent engagement of congressional leadership in the Department's continued efforts to satisfy the legitimate goals of congressional oversight, while at the same time preserving the integrity and the independence of the Department's ongoing criminal investigations and prosecutions. Leadership's recent letter represented, I think, a promising step toward reaching a resolution, as it accomplished two things. First, it narrowed the universe of documents still in dispute between the Justice Department and the House Oversight Committee. Second, it identified the specific questions that remain of concern to leadership. We are confident that the constructive discussions that have occurred since this letter can result in a mutually acceptable resolution. In all these efforts, I'm grateful for your continued support, and I would be happy to answer any of the questions that you might have. Thank you.
Thank you, Mr. Attorney General. Let me remind members that the Attorney General is with us until 1:30 this afternoon, and in order for all 40 members of the committee to be able to make comments and ask questions, we're going to need to adhere strictly to the 5-minute rule. And I'll recognize myself for questions. Mr. Attorney General, the Foreign Intelligence Surveillance Act amendments, which help protect our country from terrorists, expire at the end of this year. Do you support the extension of those amendments?
We do support them. It is the most important legislative concern of the intelligence community, and we hope that Congress will pass that reauthorization before the expiration at the end of the year.
Okay. Let me go to Operation Fast and Furious, you mentioned in your testimony. Mr. Attorney General, who was the highest level official in this administration who knew that these tactics were being used? And I'm talking about knew the tactics were being used before the death of Agent Brian Terry on December 15th, 2010.
Well, we know that the operation began in the field offices in Arizona, both in the U.S. Attorney's Office and in the ATF office there. The Inspector General is in the process of examining the
right,
way
but to your knowledge, who was the highest ranking official in the administration who knew about the tactics?
At this point, I can say that it started in Arizona, and I'm not at all certain who beyond that can be said to have been involved with regard to the use. Now, there was knowledge of it, but with regard to the use of the tactics, I don't certainly
Right.
think we
But no one other than ATF officials in Arizona, you're saying, knew about the tactics used in Operation Fast and Furious before December 15th, 2010, is that right?
I think that in terms of knowledge of the tactics as opposed to the operation itself, I don't think that anybody in Washington knew about those tactics until the beginning of 2000.
Speaking of those tactics, when were you first told or became knowledgeable about U.S. officials allowing firearms to be sold to the drug cartels in Mexico? And I'd like a specific date if you can give it to us.
I don't have a specific date. I got a letter from Senator Grassley at the end of January of 2011. I think I became aware of the tactics themselves probably in February of 2011, as I've indicated in the 7 previous times that I've testified.
Okay, and it wasn't until that letter from Senator Grassley that you knew about the firearms being allowed to be transferred to the drug cartels in Mexico?
No, it was not in the letter. The letter directed my attention to the area that ultimately led to my understanding about the tactics, but the letter itself did not mention Operation Fast and Furious.
Okay, and so once again, when did you learn about the tactics that were being used?
As I said, the early part of 2011.
Okay, and that was immediately after or several weeks after the death of Brian Terry?
That happened in December of 2010.
Okay, and is that the same date that you found out that these firearms that were connected to Fast and Furious were found at the murder scene of Brian Terry? Or did you find out about that before?
I don't know when I found out about, I don't remember when I found out about that particular fact. I would guess it would also be sometime in the early part of 2011.
Okay. Why was it, do you think, that individuals who worked for you, who were in this administration, would not have made it known to you or others outside of Arizona that firearms that were allowed to be given to drug cartels in Mexico by U.S. officials, why did it take so long for you to learn or for others to tell you? Was there a cover-up going on, or what was the explanation for you and your position not knowing more about the tactics?
Well, I think the answer is found in your question. No one knew about the tactics at the time of that initial discovery. It wasn't until the tactics were discovered that people started to understand that we had a problem here. But for those tactics, Fast and Furious was a mid-level regional investigation that, from all reports, was going on pretty successfully.
But again, you didn't find out about those tactics till, say, 6 weeks or 2 months after the death of Brian Terry. Is that correct?
Sometime in February, I think Agent Terry was killed December 10th or 14th, I believe, of December.
Okay. When was anyone in the White House first informed about the tactics that were used under Operation Fast and Furious?
I don't know.
Did you yourself not inform anyone in the White House about Operation Fast and Furious?
I'm sure there was contact between staff in the Justice Department, probably, and the appropriate people in the White House about Fast and Furious. I don't remember myself ever sharing that information with.
How would anyone in the White House have learned about it, and who would have learned about it under the normal chain of command?
I'm sorry?
How would the White House have learned about Operation Fast and Furious if not from you?
Well, through my staff and the interactions that we have with the White House counsel.
Okay,
Office.
so
That's the nature of
when
the
did your staff inform the White House about Operation Fast and Furious?
I don't know.
Were you ever curious about that?
Well, my focus was on dealing with
Okay.
the problems associated with Fast and Furious.
It seems to me that you would want White House officials to know what was going on in order to correct the problem.
My focus was on those tactics and trying to solve the problem, and not
Okay.
awfully concerned about what the knowledge was in the White House.
I
That's
understand.
my response.
I understand, but I still think the White House would have been informed. Thank you, Mr. Holder. The gentleman from Michigan, Mr. Conyers, the ranking member, is recognized for his question.
Thank you, Chairman Smith. Attorney General Holder, would you pull your mic up just a little bit closer, please? You've made reference to the ATF's multiple sales reporting program for certain types of rifles in states along the southwest border. This rule is intended to get at the real problem of gun violence on the border of Mexico. In your view, has the program been effective? Have we been stopping guns and saving lives?
Yeah, the rule simply says that for the multiple sale of certain kinds of weapons, including AK-47s, if somebody buys more than one over the space of 5 days in 4 border states, that information has to be reported to the ATF. That has led to actionable leads. It is a very measured, responsible regulation that has been upheld by a court that has considered it and said that it is appropriate, and it is also totally consistent with what we do right now and have for the last 30 years with regard to the sale of multiple handguns.
Yes. And by the way, I think we repealed the assault weapon ban, and that's led to a proliferation of weapons that I think we need to take another look at here in our legislature. Let's talk about the mortgage fraud task force of the president and how it's coming along. You know the effect this has had in our economy and on foreclosures and in families from one end of the country to the other. How's your staffing and resources picture in this context?
Well, I think we're doing pretty well. We have about, I think, 100 people or so who are presently involved in that task force. Subpoenas have been sent out. Investigations are underway. We're working, I think, very effectively with a number of U.S. attorneys as well as our partners on the state side. I think principally the Attorney General from New York, Eric Schneiderman, as well as other state attorneys general. So I think the progress that we're making there is very good.
Thank you. In 2009, you created a working group to review the department's profiling guidance that came out in 2003 under then Attorney General Ashcroft. In April of this year, 64 members of Congress wrote to urge you to revise that guidance. What's the status of the working group, and are there going to be changes to the guidance? And if you can, what would some of those changes be?
Well, we're in the process of looking at that earlier policy and seeing if, in light of experience, there are changes that need to be made. I had a meeting concerning this issue, I think, over the last 2 weeks. It would be my expectation that to the extent that changes are to be made, that those would happen relatively soon. We have an interagency, well, certainly working within the Justice Department, and I suspect we'll have to have an interagency group because there are a number of agencies whose equities are implicated by the prospective change. But it is something that we continue to look at, and something in which I've been personally involved over the last 2 to 3 weeks.
And what's the what was the goal of the so-called profiling guidance?
Well, to try to make sure that we did not hamper law enforcement, but at the same time that we had in place rules, regulations, guidance to those in law enforcement that did not, so that we did not engage in racial profiling, which is simply bad law enforcement. If one looks at Al-Qaeda, they understand that if we engage in profiling, they will be more successful. They look for, and this has been reported, people, as they call them, with clean skins. It's people who do not fit a particular profile. Those are the ones who they are trying to send to harm this nation, and that is why profiling, certainly in the national security context, as well as I would say with regard to domestic law enforcement, is such a bad idea.
Let me squeeze in my last question. Can you talk a little bit about the charges of selective enforcement of immigration law? I don't know if you've heard of any of those kinds of complaints, but can you respond to that for me, please?
Selective immigration.
Selective enforcement of immigration law.
You mean by the federal government, or?
The Arizona law and other
The states.
state,
Oh, I see,
at
yeah.
the state level. If I can
Well-
finish this question, Mr. Chairman.
Yeah, please answer the question.
We have filed suit against immigration laws that have been passed by a variety of states. The Supreme Court has obviously heard argument in connection with the Arizona law. The concern that we have is that this is inherently a federal responsibility, and that if we allow these state laws to proliferate, we'll have a patchwork of laws that will make ultimate enforcement of our immigration laws impossible. Having said that, I understand the frustration that many states feel, and I think it points out the need for a comprehensive solution to this problem.
Thank you very much.
Thank you, Mr. Conyers. The gentleman from Wisconsin, Mr. Sensenbrenner, is recognized for his questions.
Thank you very much, Mr. Chairman. Mr. Attorney General, I do want to echo Mr. Conyers' commendation of you for coming before us on a very regular basis. I know it takes a lot of your time to prepare. I also know that you don't know what's going to get thrown at you, and sometimes there will be curveballs and beanballs. I hope mine is a curveball. I want to talk a little bit about the Florida voter registration case. And it appeared in the New York Times yesterday. There was an article there about the state defending its search for ineligible voters. And Secretary of State Ken Detzner of Florida has sent a letter to Mr. Herron of the voting section of the Civil Rights Division talking about the problem. And the problem is simply this. And that is, as Florida is trying to purge its voter registration rolls of non-citizens, including illegal immigrants, people who are clearly not eligible to vote. And the Department of Homeland Security has had a 9-month delay in giving the national voter registration laws to the state. Now Mr. Herron appears to be taking the position that Florida can't do anything after the federal government has delayed giving Florida the information that it needs to do. What can be done to solve this problem?
Well, the problem with the Florida effort is that it runs counter to the National Voter Registration Act, which says you can't do this within 90 days of an election. You can successfully do that which Florida is trying to do, as has been done and has been approved by the Justice Department in North Carolina and Georgia. They did it the right way. The database that I think Florida is requesting is not necessarily the answer to these problems. That database, as I understanding, which is a DHS database, does not contain on its rolls or within that database people who are born in the United States. That database will therefore be flawed and could result in the exclusion of people from voting who are native-born Americans.
Well, the state of Florida has attempted to obtain this database for 9 months so that it could do its thing prior to the 90-day shutoff in the National Voter Registration Law. And I have a copy of the letter from Secretary of State Detzner that talks about the due process protections, such as a notification by certified mail, return receipt, 30 days to respond, hearing if requested. If the mailed notice is returned as undeliverable, then the names and addresses appear in a newspaper of general circulation in an additional 30 days. At the conclusion of the notice and hearing process, the registrar is supposed to make a final determination based upon the preponderance of evidence and allow for an appeal of any determination of ineligibility to a state circuit court. Now, you know, this is probably due process times 3 or 4 or maybe even 5 times. And, you know, I'd like to know what rights do non-citizens, and particularly illegal immigrants, you know, have to the protection of the Voting Rights Act and the National Voter Registration Act.
They have no rights, and I stand with any state official, federal official who wants to make sure that our voting system is done in an appropriate way, and that people who are not allowed to vote, in fact, do not vote. But as a result of the way in which Florida has carried this out, I saw a report that an election official in southern Florida indicated that about 450 people on the list that I believe was a woman that she got were indicated to be people who were not eligible to vote, who in fact were eligible to vote. And I think that points out the problem in the process that Florida is engaged in.
Well, you know, with all due respect, Mr. Attorney General, there is a problem. And any ineligible voter or fraudulent voter who has a ballot placed in the same ballot box as hundreds of legitimate voters ends up diluting the votes of the legitimate voters. And the federal law is very clear on that. And, you know, here the Department of Homeland Security hasn't given Florida the means to start the process out, and with all of these protections that I have just listed. And it seems to me that if your job is to uphold the law, you know, the law sets out a process to give the states time to do this, but we have another agency of the government that you're supposed to be advising as Attorney General that has prevented the state of Florida from doing this.
Well, I would say I respectfully disagree, and I point to, as I said, other states that have, I don't know all the ways in which they did it, but who successfully have implemented a policy that I would agree with. I don't think we should have people who don't have the ability, who don't have the right to vote, casting votes in our nation. North Carolina, Georgia did it.
Well, then please help Florida to do it, because apparently there's been a roadblock here in Washington, and my time is up.
Thank you, Mr. Sensenbrenner. The gentleman from New York, Mr. Nadler, is recognized.
Thank you, Mr. Chairman. Mr. Attorney General, we have made several requests to you to allow us to review the Office of Legal Counsel memo that reportedly provides the legal justification for the lethal targeting of U.S. citizens who are terror suspects. The Department has sought dismissal of cases seeking judicial review of lethal targeting by arguing, among other things, that the appropriate check on executive branch conduct here is the Congress, and that information is being shared with Congress to make that check a meaningful one. Yet we have yet to get any response to our requests. Will you commit to providing that memo to us and to providing a briefing?
Well, we certainly want to provide information to the extent that we can with regard to the process that we use in selecting targets. I gave a speech at Northwestern University. Mr. Brennan gave a speech here, I believe.
Excuse me. Will you commit to providing a copy of the briefing, a copy of the legal memo from OLC?
We will certainly look at that request and try to determine whether.
And a briefing to the members of this committee?
And we'll certainly consider the possibility of a briefing.
The possibility? You won't commit to giving a briefing to this committee?
I think that we are probably going to be in a position to provide a briefing, but I would like to hear from the involved people in the intelligence community as well as people at OLC about how we might structure such.
And you'll get back to us on that within,
Yes.
let's say, a month?
No, we can do that.
Thank you. When running for president and talking about medical marijuana being legally used around the country in certain jurisdictions, President Obama said the following, quote, "I'm not going to be using Justice Department resources to try to circumvent state laws on this issue," close quote. Apparently, the department has not followed the president's admonition. Since 2009, DOJ has conducted around 200 raids on medical marijuana dispensaries and growers and brought more than 60 indictments. It's my understanding that the department has a more aggressive record on prosecuting these cases in this administration than under the previous administration. The President clearly did not want to prioritize prosecutions involving medical marijuana, and while I understand selling and possessing marijuana remains against federal law, the citizens of 17 states and the District of Columbia believe its medical use should be legal. Given these facts, why is DOJ focused so extensively on investigating and punishing those who legally grow and sell marijuana legally under local law, contrary to the apparent intent of what the President said on the subject?
See, this is inconsistent with these little things called the facts. The Justice Department indicated in a memo that went out by the Deputy Attorney General that we were not going to use the limited resources that we have to go after people who are acting in conformity with state law, people who had serious illnesses, people who were acting, as I said, consistent with state law. But one has to deal with the reality that there are certain people who took advantage of these state laws and a different policy that this administration announced than the previous administration had, and have come up with ways in which they are taking advantage of these state laws and going beyond that which the states have authorized. Those are the only cases that
So you're saying that that you're not targeting people who are growing and distributing marijuana only for medical purposes in following the applicable state law?
Yes, we limit our enforcement efforts to those individuals, organizations that are acting out of conformity with state laws, or in the case of instances in Colorado where distribution centers were placed within close proximity to schools.
Okay. On September 23rd, 2009, you issued a memo setting forth policies and procedures governing the executive branch's invocation of the state secrets privilege. That policy requires your personal approval for the department to defend assertion of the privilege in litigation. In how many cases since September of 2009 have you approved personally invocation of the privilege?
I'd have to look at that. There have not been many. I think 1, 2, 3, something along those lines. I'm not sure. Now, those numbers get skewed a little bit because in the Second Circuit, in order to use the SEPA statute, the Second Circuit has a rule that says we have to invoke the state secrets privilege, but that I don't think is the same thing.
I have a number of other more specific questions on this that I'm going to submit to you, but I see I'm coming to my end of time, so I have one further question on this. You do not indicate in this policy whether the administration will agree to judicial review of the basis for invoking the privilege. The prior administration took the position that information could not even be disclosed in camera to an Article III judge, thus ensuring that there was no judicial review of whether the privilege was being properly invoked. What is your position as to judicial review of the information that the government seeks to withhold in two key respects? One, can a judge review the allegedly privileged information? And two, can the judge disagree with the executive branch's decision as to whether the privilege is properly invoked?
Well, I think that we have shared information with Article III judges, but at the way in which the privilege is set out, it is, I think, at the end of the day for the executive branch to make that determination. But we have put in place a process that requires multiple levels of review, standards.
Within the executive branch, but you're saying that you do not agree that ultimately a decision should be subject to judicial approval or disapproval as to invocation of the privilege?
Well, ultimately, a judge, I think, could probably override our assertion of the privilege, and then we'd have to decide whether or not we wanted to dismiss the case. But our hope is that through the process that we go through, we only invoke the privilege where it's absolutely necessary. And I think if we look at the statistics, we'll probably see that we have invoked the privilege far fewer times than our predecessors.
Well, I hope you will share those statistics with us. Okay. Thank you.
Thank you, Mr. Nadler. The gentleman from California, Mr. Gallagher, is recognized.
Thank you very much, Mr. Chairman. Good to see you again, Attorney General Holder. When your last visit here, we asked about a few issues that we'd like to get a response from. In fact, I'm disappointed that to date your office has been unable to provide answers to what I consider some very simple questions that we asked in that meeting, having to do with prosecutions of worksite enforcement cases. I'm especially interested in the number of DOJ worksite enforcement prosecutions for each of the last 4 years, the number of prosecutions of illegal workers who have been using fraudulent documents. When can I realistically expect to get a response on that?
I was under the impression that we had responded to all of the questions that were put to me either during the hearing or, as I guess we call QFers, that had been submitted to us. If that's not the case, I'll make sure that...
I have not received them. In fact, we will be happy to reiterate with specificity what those were, but it's pretty straightforward.
Right, we'll get you those numbers.
Okay.
And I apologize if you've not gotten them.
Okay, we'll work with your office. You know, we all know that many illegal immigrants are using fraudulent Social Security numbers or individual taxpayer numbers to take jobs from American citizens. I don't think there's any question about that in anyone's mind. They also receive taxpayer benefits such as child tax credits, earned income tax credits. There have been reports that some illegal immigrants are claiming tax credits for children not even living in the United States. What specific, and I want to emphasize the word specific, steps are being used by DOJ to stop this fraud, recover taxpayer money, deport the illegal immigrants who have committed the criminal fraud?
Well, we work with our partners at DHS to come up with a number of ways in which we try to make sure that people, through worksite enforcement, through reaching out to employers, to making clear what the policies are, what the law is. We use a variety of techniques to try to make sure that the kinds of people you're talking about are not, in fact, getting benefits to which they are not entitled. It is something that we have worked, I think, pretty effectively with DHS.
Would this group of individuals that I'm speaking to, about, those that have clearly committed fraud, are these folks on a priority list for deportation, or are they among those that have been given an exemption or a review to get a temporary green card?
No, I mean, I think that we have certainly prioritized those people for deportation, and we have tried to place at the head of that list people who potentially pose criminal problems for those of us in the United States or in the immigrant community, people who are engaged in violent acts. Those are the ones who we are emphasizing, but it doesn't mean that those further down the list are not also people who we're trying to deport, if that's
well, we know, and I'm glad to hear that acts of violence by criminal aliens are at the top of the list, but the fraud issue to me is also an offense that should be very close to the top of the list when they're stealing the taxpayers' dollars that could otherwise be used to help your department, for instance. Also back in December, we talked about DOJ addressing the issue of Medicare fraud. And we know by many accounts there's as much as $60 billion a year that is being used as being stolen from our Medicare program fraudulently. What steps is DOJ taking to increase prosecutions on Medicare and also in Medicaid fraud?
I'm sorry. We're working with our partners at DHS. Kathleen Sebelius and I, the Secretary at HHS, have been going around the country and expanding what we call these HEAT strike force teams to increase the federal presence and our investigative capacity in those cities where we have identified these problems. And what we have seen is that we have received in the settlements, in the prosecutions that we have brought, record amounts of money brought back into the federal government. And as I indicated in my opening statement, for every dollar that we spend in enforcement, we bring back $7 to the federal government. And it's something that I think should be funded at as high a level as we possibly can, our enforcement efforts.
One closing question. Could you provide information to the committee on what specific enforcement is taking place in this area in California, specifically Southern California, and more specifically in and around the area of Los Angeles and areas like Glendale, California?
Okay.
Yeah, we can do that. I can certainly make clear to you what we're doing generally with regard to all the cities that we have targeted, but I can also share with you what we're doing in California. in the area of California that you're talking about.
Thank you, Mr. Chairman. I yield back.
Thank you, Mr. Gallagher. The gentleman from California, Mr. Berman, is recognized.
Well, thank you very much, Mr. Chairman, and welcome, Attorney General. I want to start by commending you and the Department for your diligent work defending U.S. taxpayers against fraud by government contractors. Every year I watch the total amount recovered for taxpayers under the False Claims Act increase, and I'm grateful for the work that the Department and whistleblowers do together to protect our tax dollars. I think we're now up to something just over $30 billion, and a lot of my colleagues today are focusing on their beefs with you today. I want to talk about this subject because here I think the Justice Department and you are doing this right, and it seems the law is quite effective, and I'd like to make sure it stays that way. Earlier this year, you invited me to take part in a commemoration of the 25th anniversary of the False Claims Act, and though I wasn't able to participate in the panel discussion that followed the main event, I am told that one of the issues discussed on that panel was whether or not we should change how relators are compensated for their efforts in recovering on behalf of the taxpayer. In October of last year, the United States Chamber of Commerce put out a report suggesting that a hard cap of $15 million would be adequate to compensate any relator. Their logic seemed to be that that amount would cover most people's future earnings if their efforts as a whistleblower kept them from working again. The report also suggests that such a cap would not deter whistleblowers from pursuing qui tam cases because in their study of 26 cases, the whistleblowers responded to a question about why they were willing to bring suit, and most of them said that they did it because it was the right thing to do. I believe that. But I also know for a fact that the whistleblowers put themselves at tremendous risk when they make the decision to file suit and try to recover on behalf of the government and the American taxpayer. These cases are expensive to pursue, and they can last for years. They require commitment, and I don't know if a general good feeling about, quote, doing right, unquote, is what will make someone remain committed to the cause for the long haul. Right now, relators can be awarded a percentage between 15 and 30%, depending upon certain factors, such as whether or not the government joined the relators. In my mind, as plaintiffs, in my mind, and I think the history of the Act bears this out, this percentage share encourages a relator to pursue a case until they can recover an amount equal to the entire impact of the fraud, as opposed to settling when the case goes too long, perhaps because they know there is a hard cap and they can only recover so much money. Though the Chamber argues that a hard cap would save the government money, I have to wonder how many cases it would deter or at least reduce the recovery for the taxpayers. In today's world, where some of these cases recover billions of dollars, if a hard cap deterred even one such case, it would be a very costly endeavor for taxpayers. When we considered the False Claims Act amendments in 1986 and in revision since, proposals to enforce a hard cap have not been well received. Of course, there are reasons that defendants fighting qui tam suits would want to limit damages, but I'm more focused on what works best for the taxpayer. I believe what we have now is working well. I sent you a letter on this subject earlier this month, but I wonder if you could share some thoughts with me now about whether the department remains committed to relators being awarded a percent share or if you support a shift to a hard cap.
Well, I have to say that I'm not totally familiar with the proposal that you have described, but I can say that the Act, as it is presently constructed, is working extremely, extremely well. And you're right, we asked you to come to the Justice Department to celebrate the success that we've had over the past 25 years with regard to an act that you were instrumental in passing. Over the past 25 years, we've had nearly 8,000 qui tam cases that have been filed that have yielded more than $21 billion in recoveries. $21 billion in recoveries for the United States, $3.4 billion in awards to relators. In fiscal year 2011 alone, the department recovered more than $2.78 billion in qui tam cases. Relators received about $530 million as their statutory shares. The statute, as it is presently constructed, works and works quite well. I would be reluctant to fool around with a formula that for the past 25 years has shown to be an effective tool in getting at fraud and incentivizing people to stay involved in the process and working with government as partners. Now, again, I will look at it, but I have to tell you that on the basis of my examination of the rule as the regulation as it exists, the statute as it exists, I'd be extremely reluctant to tamper with it.
Thank you, Mr. Berman. The gentleman from Virginia, Mr. Goodlatte, is recognized.
Thank you, Mr. Chairman. General Holder, both the criminal division head, Lanny Brewer, and his deputy, Jason Weinstein, had knowledge that the ATF let a bunch of guns walk, and some were recovered in Mexico, all related to the Fast and Furious scandal. In a prior operation, when they reviewed the February 4, 2011 letter that falsely denied the ATF knowingly allowed the sale of assault weapons to a straw purchaser who transported them to Mexico, do you think it is a serious offense for an individual to mislead the Congress?
Well, first, with regard to the question, I think you've got it a little off there. The two individuals you talk about, Mr. Weinstein, Mr. Brewer, did not know about the tactics used in Fast and Furious until the beginning of last year.
But they did acknowledge that, quote, ATF let a bunch of guns walk.
And that was in
and, quote, some were recovered in Mexico, end quote.
That was in connection, I believe, with Operation Wide Receiver. That
Correct.
Occurred in the prior
Correct.
administration.
Correct. But they did not acknowledge that in their communication with the Congress. So my question to you is, do you think it's a serious offense for an individual to mislead the Congress about what they know about what's going on in your department?
Well, to the contrary, they did acknowledge to Congress that they did have that information about Wide Receiver and said that it was a mistake on their part not to share it with the leadership of the department. That prior knowledge also indicated that it was a mistake on their part not to use that prior knowledge when they were looking at Fast and Furious to try to understand that they should have been more sensitive to what was going on with regard to Fast and Furious.
What consequences have they faced as a result of that?
Well, they are certainly, they have apologized. They have been...
apology is a good thing, but it's not a consequence for gross mismanagement of an operation that cost the life of one border security guard. Why haven't these two most senior political attorneys in the criminal division faced any consequences at all for their participation in this lack of being forthcoming to the Congress and to others, and for not putting a halt to the subsequent activities that took place?
Well, again, I think your premises are wrong. They have been forthcoming to Congress. They have testified or been interviewed in a way that I think is consistent with the facts. They've been very forthright about.
But what about the underlying decision of allowing this to go forward?
And that's the other part of, I think, your premise that is not right. They were not in charge of, they did not have operational control of Operation Fast.
But when they
and
knew
Furious.
about it, what did they do about it?
Well, that happens about the same time everybody in Washington finally hears about these tactics. They were assured by the people in Arizona that the gun walking, in fact, did not occur. That is the information that they got. If you look at the materials that we submitted to Congress, the deliberative materials that we submitted to Congress around the February 4th letter, you will see that neither Mr. Brewer nor Mr. Weinstein had information about the use of, they were in fact assured that gun walking tactics were not employed with regard to Operation Fast and Furious.
Now, with regard to the prosecution of Senator Ted Stevens in Alaska, in that case, Senator Stevens was falsely prosecuted. His reputation was ruined. He was not reelected to the United States Senate. And it was determined that the U.S. prosecutors were engaged in outright fabricating of some evidence, deliberately withholding information that revealed the senator's innocence, and ultimately they were held in contempt of court, and the charges against Senator Stevens were dismissed. But what consequences have they faced? To my knowledge, the only consequences for engaging in the outright fabrication of evidence and deliberately withholding exculpatory evidence that would have revealed the senator's innocence was that one of them was suspended without pay for 40 days and the other for 15 days. Why were not these individuals fired?
Well,
Some would say they should have been disbarred for that activity. That's not the purview of the Justice Department, but certainly no longer having them on the payroll of the Justice Department would be a good step in the right direction, wouldn't it?
Well, again, there are a number of premises there that are inconsistent with the facts. This is a case that was brought by the prior administration. It was not dismissed by the court. I dismissed the case. This Attorney General dismissed that case after had concerns about the way in which we had failed to turn over information that the defense had a right to. The OPR report looked at the matter and made a determination that they did not do so intentionally. It's inconsistent, or it's at tension with the report that was done by Mr. Schulke, and the recommendation made by those people charged with the responsibility is that those penalties should be imposed, I guess 40 days and 15 days. This is not something that the Attorney General, the Deputy Attorney General is involved in. The determinations as to how those cases, what punishment should be made, or findings of fact, is done by people who are career within the department. The same thing happened with regard to the determination concerning Mr. Yu and the creation of those OLC memos involving interrogation techniques. Whether or not the Attorney General agrees or disagrees with what the career people do, the tradition in the department is that that is something for career people charged with that responsibility to ultimately determine.
Mr. Chairman, I would ask that a letter dated February 4, 2011, signed by Robert Weiss, Assistant Attorney General, which I think rebuts the statements made by the Attorney General with regard to what was known and what was not known about Operation Wide Receiver and Operation Fast and Furious be made a part of the record.
With that objection, the documents will be made a part of the record. The gentleman from Virginia, Mr. Scott, is recognized.
Thank you, Mr. Chairman, and thank you, Mr. Attorney General, for being with us today. Mr. Holder, you've been criticized for not turning over information upon request to the to one of the committees. Did some of those requests involve information pertaining confidential informants and wiretaps under seal, court order seal, and information related to ongoing investigations?
Yes, that is true, but we have turned over a very significant amount of information. Now, we have collected data from 240 custodians. We have processed millions of electronic records. We have turned over 7,600 pages on 46 separate productions.
Well, could you tell us what's wrong with handing over information involving confidential informants, wiretap information on the court seal, and information related to ongoing investigations?
We are by law prohibited from discussing or turning over the contents of wiretap-related material. There is a criminal provision that has a 5-year penalty that prevents us from doing that. And there's also a very practical reason. There are concerns that one would have about people who are involved in these matters. You might put victims' safety at risk. You might put at risk the success of a prosecution. Those are all the reasons why there are very tight restrictions on the provision of material connected to wiretaps.
Thank you.
Would the gentleman yield?
I have very little time.
I'll be very brief.
Go ahead.
We did not request any wiretaps under seal, since I'm the person who signed the subpoenas.
Thank you. Reclaiming my time. Mr. Attorney General, Section 5 is there to prevent discriminatory election practices from going into effect. If you didn't have Section 5, discriminatory voting changes could go into effect until the victims of discrimination raise enough money to get into court to get an injunction. Those who benefit from the discrimination would get to legislate until the law is overturned, and when overturned, they would get to run as with all the advantages of incumbency as a result of their discrimination. And so there's an incentive to keep discriminating. But under Section 5, the burden is on covered states to demonstrate that an election change does not have a discriminatory effect on purpose. Section 5 covered states were not selected randomly. They were covered the old-fashioned way. They earned it with a history of discrimination. Now, how is the Department of Justice using Section 5 to prevent discriminatory voting practices? And specifically, what are you doing in Florida to prohibit purging of voters, according to press reports that include decorated war veterans clearly eligible to vote?
Well, I think first, just a bit of an overview, and this will take just a second. You have to understand that over the course of the time in which I've been Attorney General, we have looked at about 1,800 requests for pre-clearance under Section 5. We have opposed 11. 1,800 requests, we have opposed 11. Now, included among those is what Florida has been trying to do with regard to the Section 5 covered counties, that one of those changes, which a federal judge has already said is inappropriate. Section 5 was reauthorized by a near unanimous Congress, signed by President Bush, findings made by this Congress that the need for Section 5 continues, reauthorized, I believe, until 2031. It is the position of this Department of Justice, and certainly this Attorney General, that we will vigorously defend and vigorously use Section 5. The need for it is still there.
Thank you. The first bill this president signed was the Lilly Ledbetter Act, prohibiting dealing with discrimination in employment. One of the things that, talking about discrimination in employment, in 1965, President Johnson signed an executive order prohibiting all discrimination in employment with federal contracts. I understand this administration still allows discrimination in federal contracts based on religion if it's a so-called faith-based group. My question is, do they need permission or certification to qualify for the right to discriminate, or do they just get the right to discriminate based on the fact that they're faith-based organizations using federal money?
Well, I think we're committed to ensuring that we partner with faith-based organizations in a way that's consistent with our laws, our values, and the department will continue to evaluate legal questions that arise with respect to these programs and try to ensure that we make sure that we ensure that we fully comply with all of the applicable laws.
Does that mean they can discriminate?
The gentleman's time has expired.
I think it was a yes or no answer.
Okay. Mr. Attorney General, go on and, if you would, answer the question.
As I said, we try to do this. We look at these policies and try to make sure that they act in a way that's consistent with law.
Oh, okay. Thank you, Mr. Scott. The gentleman from California, Mr. Lundgren, is recognized.
Thank you very much, Mr. Chairman. Mr. Attorney General, I just follow up on what my friend from Virginia, Mr. Goodlatte, had to say with respect to the Stevens case. I realize that you reassigned people after that. I realize it was an investigation and indictment that came before you were Attorney General. That's not the point. The point is, if you have no real consequences now, you're going to have no real changes in the future. That was conduct that was stated by the judge to be outrageous. He held a hearing as to whether a new trial ought to be called. Before he made a ruling, you did come forward with a motion to dismiss, recognizing the problems. Internally, the investigations showed widespread misconduct among the whole team, and yet I am unaware of any buddy that was fired. And Senator Stevens lost his election, but more importantly, he lost his reputation. And I happen to think that in the absence of serious action taken against employees of either the Department of Justice Prosecutorial Corps or the FBI, that frankly the message is not seriously received. So I would just like to state that for the record. Now, Mr. Attorney General, if I were lucky enough to be invited down to meet you or see you at your office at the Justice Department, wouldn't I have to show a government-issued photo ID to get in to see you?
You might.
If I were to go to the federal courthouse here in D.C., either as a party or as an attorney, wouldn't I have to show a government-issued photo ID?
That's not been my experience. Here in D.C., I don't,
Some federal courts, are you aware that that's required in some federal courts in this land?
I don't know.
Are you aware that if I have to come here from California to exercise my constitutional right of travel and as an ordinary citizen, petition the government for a redress of my grievances, I have to show a government-issued photo ID, do I not?
That one, yes. To get on a plane, you've got to have a photo ID.
Okay. And that does involve the constitutional right of travel among the states, correct?
Yep. Supreme Court has said that the right to travel is of constitutional dimension.
So is your Justice Department investigating the discriminatory effect of those laws with respect to someone's constitutional right to travel or constitutional right to visit you? I mean, the Constitution doesn't say petition the government for redress of grievances only goes to some people. I mean, if I've got a complaint with the Justice Department and want to come to the Justice Department, are you inhibiting me, affecting my constitutional right by requiring me to show a government-issued photo ID?
No, but let's get to the bottom line here. That may.
Well, no. My question
All right,
is.
well, I'll give you an answer. The answer.
Well, that's all I'm asking.
The answer is that with regard to the limited things that you have discussed that might not have an impact on your constitutional right, but that some of the laws that we have challenged do have an impact on a person's ability to exercise that most fundamental of constitutional rights, and that is the right to vote.
It's a fundamental right to petition the government to redress my grievances. Don't you think that is as important as, quote unquote, the right to vote?
I would agree with President Johnson with what he said after the 65 Voting Rights Act was passed, with that the voting rights, that voting is the most important right that we have as American citizens. It distinguishes this country and makes it exceptional as compared to other nations around the world.
I also happen to think it's important that we have the opportunity to petition the government to redress the grievances. I think that is as fundamental a
But through the vote,
right.
I can change the government. I have that ability through.
Well, you can
vote.
sue me in court. You can threaten to sue me in court, and as a proud individual American citizen, I suppose I have a right to at least talk to you about whether you're going to bring me before the court and bring the majesty of the government against me, and I would think that that is as important a right. Now,
Well, I certainly have that ability to talk to you, but if I disagree with you, at the end of the day, I have the ability to cast a ballot.
but I can't even come in and talk to you unless I show a government-issued photo ID is my point. Now,
No, that's not true in the government. That's not true in the Justice Department. If you were to show up at the Justice Department, somebody could vouch for you, and you could come into the department, and we could have a very
Is that right?
I'm sure, conversation.
okay, I haven't tried that with the TSA. That doesn't work very, very well in terms of being able to get on an airplane to fly back here to knock on your door to get to see you.
Well, there are terrorists who are trying to bring down planes, as we have seen over the course of the last, I guess, 12 years.
And there are people who cheat about voting when they don't have a right to vote.
We do not see that to the proportions that people have said in an attempt to try to justify these photo ID laws. All of the, I think, empirical and neutral evidence shows that the questions of vote fraud do not exist to the extent that people say that it does exist.
So the Supreme Court was wrong in its decision 2007 when it said that states have a legitimate interest in requiring photo IDs for voters even absent evidence of widespread fraud in order to inspire confidence in the electoral system. You disagree with the court on that?
You know what's interesting there, and please expand.
If you will, answer the question, then we'll move on.
Sure. The Supreme Court, the Crawford case is fundamentally different from that which we're talking about now. That was not a Section 5 case. Indiana is not covered by Section 5 of the Voting Rights Act. And I would just, with all due respect, Attorney General McCasey talked about the Crawford decision, the Indiana decision, and this tells how it's different. He says that the court acknowledged the undeniable fact that voter ID laws can burden some citizens' right to vote. It is important for states to implement and administer such laws in a way that minimizes that possibility. He then said, we will not hesitate to use the tools available to us, including the Voting Rights Act, if these laws, important though they may be, are used improperly to deny the right to vote. That is Michael Mukasey talking about the Indiana Crawford decision. Michael Mukasey, not Eric Holder, Michael Mukasey.
Thank you, Mr. Lundgren. The gentleman from North Carolina, Mr. Watt, is recognized.
Thank you, Mr. Chairman. Let me start by just expressing my disappointment that some of my colleagues are spending so much time advancing the notion that we should be disqualifying people from exercising the most basic right that they have in our democracy, the right to vote, and that and that this is the Judiciary Committee in which these arguments are being advanced is just disappointing to me. Second, I want to applaud the Justice Department for some work that they're doing in my congressional district in particular. Some very high-level cases fighting drug trafficking, protecting against child predators, a bunch of money we spent on the COPS program, and the most vigorous supporters of the COPS program are the most conservative sheriffs in my congressional district because they've been able to access funding to beef up their law enforcement capacity. So I won't go back to the voting rights part of this because I think I'll get too emotional about that. Let me deal with the thing that's under my subcommittee's jurisdiction, the one that I'm the ranking member on, and that's we made some efforts to try to do something about piracy. We were not successful legislatively, but the problem has not gone away. A recent article in the USA Today notes the proliferation of dangerous counterfeit products that pose safety concerns for the American public. Many of these products, including counterfeit pharmaceuticals, are available online and come from foreign sources. In January this year, the Department of Justice issued indictments against Mega Upload, a foreign-based website that was charged with illegally infringing the copyrights of American businesses. And now I note that some group has, what's it called, Anonymous, unleashed a series of cyber attacks in the aftermath of the indictments against Mega Upload. So now there's a connection between piracy on the one hand and cyber security on the other hand. Can you just talk to us about the real threats that we have in that area, both on the piracy side of this issue and on the cyber security and their connections just a little bit, so we'll have some background that at least informs the American people how serious the problem is?
I mean, the piracy issue is has a number of dimensions to it. It is an economic issue. It is a jobs issue. When the theft of our intellectual property, or the methods that we use to produce things, is stolen by other organizations or by other countries, it has a direct impact on our economy. There is also a safety factor. Health items, medicines that are produced in a way that are inconsistent with the great standards we have in the United States, then sold back to the United States or sold in other countries, can put people at risk. The whole question of various parts that can be used in airplanes, other things that are not done in a way consistent with the way in which our intellectual property standards are done, can have a negative impact on safety in that way. So the piracy question is one that has economic consequences as well as safety consequences. If one looks at the whole cyber issues, again, these are national security issues. The ability of foreign countries or organizations to have an impact on our infrastructure, to use cyber tools to ferret out secret information from the United States, all put our nation at risk and is worthy of the attention of, I think, this committee, this Congress, and the executive branch. And I would hope that we would be able to work together to come up with a way in which we could craft tools to deal with what is truly a 21st century problem.
I thank you, and at the risk of not going over time like some of my colleagues have, I'll just stop there because any other question I could ask would be well over into the next person's time. So I'll yield back, Mr. Chairman.
Thank you, Mr. Watt. The gentleman from California, Mr. Issa, is recognized.
Thank you, Mr. Chairman. Attorney General, December 14, 2010, Brian Terry was gunned down, and we began knowing more about Fast and Furious shortly thereafter. But you have said People representing you have said repeatedly you didn't know about it before then. I've sent you a number of letters. Senator Grassley sent you a number of letters. You mentioned in your opening statement the Speaker's letter. The Speaker did not limit the scope of the subpoenas you're under an obligation to respond to. He simply asked you for response to two key areas. He did not revoke any subpoenas. However, you implied that we were working together when, in fact, since May 18th, nothing has come from your department, not one shred of paper. I want to ask you, first of all, today, have you and your attorneys produced internally the materials responsive to the subpoenas?
We believe that we have responded to the subpoena.
No, Mr. Attorney General, you're not a good witness. A good witness answers the question asked. So let's go back again. Have you and your attorneys produced internally the materials responsive? In other words, have you taken the time to look up our subpoena and find out what material you have responsive to it, or you've simply invented a privilege that doesn't exist?
You're saying internally. Have we?
Internally, have you pulled all that information?
We've looked at 240 custodians. We have processed millions of electronic records, and we've reviewed over 140,000 documents and produced to you about 7,600.
So 140,000 documents. How many documents are responsive but you are withholding at this time?
Well, we've produced 7,600.
Look, I don't want to hear about the 7,600.
Chairman, I would beg to allow...
The lady is out of order. Would the lady
Mr.
please
Chairman,
suspend?
in parliamentary
This is my
inquiry,
time.
excuse me, Mr. Chairman, I would beg to allow the Attorney General to be able to finish his answer.
The Attorney General will be allowed to answer the question.
I thank the
And
Chairman.
the Attorney General will have more time to do that if we don't have interruptions.
And I would like my time reclaimed that was
the
used up
gentleman
by the
will
lady.
be given an additional time to
Mr.
allow
Chairman, I
that.
suggest we take back the time that Mr. Lundgren used, the 2 minutes over his time that he used, and
You want to give me additional 2 minutes? I'm fine with it.
no, I'm going to give you the 45 seconds I yielded back, but if we're going to apply a rule on one side of this aisle,
Let's get back to
then
regular.
we ought to apply the rule
Let's get back to
consistently. That's
regular order. The
point I'm
gentleman
trying
from
to make.
California has the time, and the Attorney General will be allowed to answer the question.
Isn't it true, Mr. Attorney General, that you've not produced a log of materials withheld, even though our investigators have asked for it?
I know that, I'm not sure about that. I know that the...
Okay, I'm sure you didn't, so let's move on. March 15th, 2010, before Brian Terry was gunned down. April 19th, 2010, before Brian Terry was gunned down. May 7th, 2010, before Brian Terry was gunned down. May 17th, 2010, before Brian Terry was gunned down. June 2nd, 2010, before Brian Terry was gunned down. July 2nd, the real date of our independence, 2010, obviously earlier, before Brian Terry was gunned down. These wiretap applications, which we did not subpoena, but which were given to us by a furious group of whistleblowers that are tired of your stonewalling, indicate that a number of key individuals in your administration, in fact, were responsible for information contained in here that clearly shows that the tactics of Fast and Furious were known. They were known and are contained in these wiretaps. I understand you've read these wiretaps since we brought them to your attention. Is that correct?
I have read them, and I disagree with the conclusion you've just reached.
So let me go through a very simple line of questioning, if I may, Mr. Attorney General. James Cole, Deputy Attorney General, has written that the Department has a greater obligation than just checking the legal sufficiency and approving wiretap application. He thinks that applications also have to comply with DOJ policy. Is that correct?
Applications have to agree with DOJ policy?
That's what he said.
Sure.
Okay. During a transcribed interview, Deputy Assistant Attorney General Jason Weinstein testified that senior officials approving the wiretap applications do not read the wiretap applications. Is this practice acceptable to you?
They read summaries of the applications. That is a process that has been used by this administration and by all previous administrations. It is the way in which the Office of Enforcement...
And are you aware that federal judges, to your knowledge...
Can I answer my question? The question you've asked?
No, you've given me a sufficient answer considering the amount of questions I have and the amount of time I have. You're okay with that practice? You've already answered that. So, would you agree that senior officials are responsible for documents they sign? I would assume the answer is yes. So now let me ask you the question. Jason Weinstein, is he responsible for what is in these wiretaps?
Is he responsible?
He's a responsible officer under statute. Is he responsible for them even if he only read a summary?
He did not create those affidavits. He did not create that material. He would have been a person as a deputy assistant attorney general who would have reviewed the material.
So when Congress writes a statute that requiring certain individuals be responsible, such as Jason Weinstein, Lanny Brewer, and yourself.
Regular order, Mr. Chairman.
No.
Regular order, Mr. Chairman.
I'm in the middle of a question.
The Attorney General will be allowed to answer this question.
And ask the question.
I'm
Mr. Chairman.
halfway through it if you'll quit interrupting. If in fact the statute says they're responsible, and if in fact they're not read, then in fact, how are the American people to understand who is responsible for what is contained in these
Attorney General will be
documents
allowed to answer
being
this
in
question.
fact, because anyone of ordinary reading, including the ATF director, former director Melson, anyone reading these, according to him, would be sick to their stomach because they would be immediately aware of
Does he
the
have
tactics.
a question, Mr. Chairman?
So, who is responsible, Mr. Attorney General?
All right. You really conflated a bunch of things here. The responsibility...
You've delivered so little and
Regular
done so much
order
well.
now, Mr. Chairman. Will he be allowed to answer the question now?
The Attorney General will be allowed to answer the question, but I'd appreciate no more interruptions so the AG can answer the question.
The responsibility about which you speak is, in fact, the responsibility of a deputy assistant attorney general looking at those summaries to make sure that there is a basis to go into court and to ask that court to grant the wiretap based on a determination that a responsible official makes that probable cause exists to believe that a wire facility has been used in the commission of a crime. They do not look at the affidavits to see if, in fact, to review all that is engaged, all that is involved in the operation. I have read those now. I have read those. I've read those. I've read them from wide receiver as well. And I can say that what has happened in connection with Fast and Furious was done in the same way as wiretap applications were done under the previous administration in wide receiver. I've looked at the summaries, and they acted in a way that's consistent with the practice and the responsibility that they have as defined by the statute.
Thank you, Mr. Issa. The gentlewoman from California, Ms. Lofgren, is recognized.
Mr. Chairman, before...
Does the ranking member wish to speak out of order?
If I may, please.
The gentleman is recognized.
I think that the previous questioning was the first note of hostility and interruption of the witness that I think has been uncharacteristic of what we've been doing here so far today. And I'd like to ask the chair to admonish all the witnesses from here on out to please try to, all the members from here on out to please allow the witness to finish his answers.
Would the gentleman yield?
Of course.
You know, I appreciate that there was hostility between the Attorney General and myself.
No,
I would
well,
hope that
just for the record,
I would hope that the ranking member would
For the record, no
understand
hostility on my part.
that in fact most of it was produced by the fact that I have a great many questions and a relatively little period of time in which to get answers, and that for a year and a half my committee, through subpoena and interrogatories, has been attempting to get answers for which this witness has basically said he asserts a privilege without
Parliamentary
in fact, a law.
inquiry, Mr. Chairman.
Well,
The gentleman from Michigan has the time.
Parliamentary inquiry, if the gentleman
just make
will yield.
I'd like to yield to the Attorney General at this point, please.
Well, with all due respect to Chairman Issa, he says there's hostility between us. I don't feel that, you know. I understand he's asking questions. I'm trying to respond as best I can. I'm not feeling hostile at all. I'm pretty calm. I'm okay. So, you know.
Let me assure the gentleman from Michigan that the Attorney General will be allowed to answer future questions, and the gentlewoman from California, Ms. Lofgren, is recognized for her questions.
Thank you, Mr. Chairman and Mr. Attorney General. Thank you for being here with us. When you were last before us in December, I asked you about a case involving the seizure of a domain name called thejazz1.com for alleged copyright infringement. In December, you said you were unfamiliar with the case, but that you would certainly look into it and get back to me. Since that hearing, not only have I not heard from you, but new details have surfaced, and therefore I'd like to revisit the issue. To refresh everyone's memory, the Jazz One is a blog. It's a blog dedicated to discussion of hip-hop music. And in November of 2010, the domain name of the site was seized as part of ICE's operation in our sites and on an application by prosecutors in your department. After the government seized the domain name, the owners filed a request for the government to return it to them, and under the law, the government had 90 days to initiate a full forfeiture proceeding against the domain or else return the property. However, in this case, that deadline passed with no action. When the website's lawyer inquired with the department's lawyers, he was told the government had filed an extension but under seal. The website was given no notice, and they were never given an opportunity to appear in court and to respond. And I have talked to the representative of the website, and he assures me that he made diligent efforts to try and actually appear and make his case. When he asked for proof that the extension existed, your department's lawyers basically said they'd have to trust them. Now, this happened 2 more times. Finally, in December of last year, more than a year after the original seizure, the government decided that it didn't, in fact, have probable cause to support the seizure and return the domain. Now, we now have unsealed court records, and we know that ICE and your department were actually waiting for the Recording Industry Association of America, which made an initial allegation of infringement, to provide detail, apparently proof. And I've reviewed the affidavit, which I'd ask unanimous consent to put into the record, that in September of 2011, 10 months after the seizure, the ICE agent was still waiting for information from RIAA to give probable cause. Now, here's the concern I have. Blogs are entitled to First Amendment protection, and I think it's the law that you have to have probable cause before you seize things. You can't seize things, have secret proceedings in the federal court, and then a year later come up with probable cause. So here's my question for you. It looks to me, and I'd say another issue as to websites. I mean, this isn't like a car that's stolen is going to disappear or a bag of cocaine. It's a website, so the evidence can be completely preserved even without seizure. So I think the issue of seizure does need to be visited with us. But I want to know what the department's posture is. If an ICE agent is behaving recklessly in an investigation, as it seems to be in this case, don't the prosecutors in your department have an obligation to reject faulty affidavits? Do you think that the ex parte process that was included here is proper and consistent with the First and Fifth Amendments to seize a domain name that has First Amendment protection for a year without any opportunity for the owner to be heard?
As with all domains that are seized or were seized, I guess, in operation in our sites, I believe that the seizure that you referenced was conducted pursuant to a lawful court order and the procedures that the department followed in that case, including the ex parte procedures you mentioned, were consistent with the statutes that authorize the seizure and forfeiture, and also consistent with due process protections that those statutes provide.
So you're suggesting that the representation, which turned out to be false under the initial affidavits, which I again would ask to be made a part of the record, those false affidavits were sufficient to have ex parte communications and sealed and secret proceedings in the federal court to suppress this speech for over a year?
No, I mean, clearly, if material was submitted that was false in an underlying affidavit,
or at least misleading, if I may say
that would not be an appropriate basis for action on behalf of the government. The seizure and forfeiture of property is a really powerful tool that the government has, and has to be used judiciously. And to the extent that there are problems along the lines that you have described, that would be of great concern. Though we should not be in court trying to do the kinds of things that I have described here. name seizures, if the underlying material is not consistent with the facts. That's something we shouldn't be doing.
Well, as I say, in last December, you were going to get back to me, and I know you have many things to do, but I would appreciate, I'll ask again, if I could get a report on this specific case, and certainly, as my colleague, Mr. Waters, has mentioned, there are important enforcement issues that need to go on. I do not disagree with that. But we also have to be very careful about the First Amendment and the Fifth Amendment. I hope that you do not disagree with that.
Thank you, Ms. Lofgren. And without objection, the document that the gentlewoman referred to will be made a part of the record.
Chairman, I have a parliamentary inquiry, please.
The gentlewoman will state her parliamentary inquiry.
I appreciate it very much, Mr. Chairman. A gentleman from California, in his statement about his own subpoena, mentioned today that he did not request wiretaps under seal. In Mr. Ice's contempt citation, the wiretap applications document the extensive involvement of the criminal division.
Would the gentlewoman state her parliamentary
In the
inquiry?
Fast and Furious. Yes, I will. My question is, did anyone review with the Justice Department before this hearing
That is not
whether
a
the
parliamentary
use of this
inquiry.
leaked information will harm the Department's ability to bring justice
Ms.
to those who
Jackson-Lee,
violated our laws?
That is not a
It
parliamentary
refers to the
inquiry.
questioning of Mr. Issa. Mr. Issa made
gentleman
this
is-
in this hearing. If not, how do we know that the use of the information during this hearing, if asked, is
Ms.
consistent with the
Jackson-Lee, we're
interests of
going
law
to have to
enforcement?
deduct this from your time if you continue. That is not a parliamentary inquiry.
I believe it is, Mr. Chairman, but I hope that we have reviewed this
Gentleman from
information.
Virginia, Mr. Forbes, is recognized for his questions.
Thank you, Mr. Chairman. General, thank you for being here today. And I think despite all the rhetoric, we know that this committee is not asking you to break the law regarding what you say or information you provide to Congress. It's just, as you know, it doesn't matter if you appear in Congress 7 times or 70 times if when you're asked, you say, I don't know, to the questions that are most pertinent. Or it doesn't matter if you supply 7,000 pages or documents or 700,000 pages if they're not the proper papers to answer key questions. So I want to begin where you began, and that was the standard that you said that you have in the department, which is that every action is guided by law and facts and nothing else. I think I stated that correctly. Is that fair?
Well, certainly when we're at our best, that's what happens.
We know that every cabinet secretary doesn't adhere to that standard. In fact, we have in a paper today the fact that several cabinet members were required to come to a meeting at the Democratic National Committee headquarters where the campaign manager, the top strategist for the campaign, the executive director of the Democratic National Committee was there telling them the actions that they should take, and 4 items: to help the president win re-election, regarding the campaign structure, the importance of the Electoral College, and the importance of staying on message. The question I want to ask you this morning is, I know that you're familiar with David Axelrod, who's the Obama's top campaign strategy, and to the best of your knowledge, has Mr. Axelrod or anybody on his behalf or anybody on behalf of the campaign had any discussions with you or members of the Justice Department regarding actions that you should or should not take, messaging that you should or should not make, or hiring decisions that you should or should not support?
No, absolutely not. I mean, one of the things that I like a great deal about my interaction with people in the White House is that, and I think they take their lead from the president, is that they have respected what I'd call a wall that has to exist between the Justice Department and the political operation that goes on in the White House. I've not had any of that kind of interaction.
So there have been some publications out, and of course we never know whether these publications are accurate or not, but at least in one book that claims that you and Mr. Axelrod had some type of confrontation when he was trying to get you to hire someone, and you're saying that's not accurate at all. You've never had any kind of meetings with him regarding any hiring decisions at the Department of Justice.
No, we talked about, not a hiring decision, we talked about ways in which we might improve the ability of the Justice Department to respond to political attacks that were coming my way. Now, David Axelrod and I are good friends. He's a close friend of mine. We have a great relationship. He's a person I respect a great deal. We worked together on the campaign while he was at the White House, but he's never done anything that I would consider inappropriate.
But then what you're saying is you have had contact with Mr. Axelrod, campaign strategists, about how you should handle different attacks coming to you as Attorney General, correct?
Yeah, I mean, there's a political dimension to the job that I have as Attorney General. I mean, the reality is that I don't sit up in an ivory tower and just do law enforcement. I am the subject of attacks. I'm a person who was seen by some as pretty controversial, and there are times, or at least there was that time, when I was looking for some help in that regard.
So you have had those discussions. Did he ever try to encourage you to hire or put any particular person at the Department of Justice?
No.
With Fast and Furious, there have been a lot of discussions about it, and we know that's a big item, not just for us, but the ambassador to Mexico has said that operation, which took place under your watch, has poisoned the Mexican people and really put a strain on strides we've made in 2 successive administrations in the United States. He's been concerned that the investigation hasn't been completed. Have you ever had any consultation with the White House or anyone with the campaign or with Mr. Axelrod about messaging related to Fast and Furious?
About messaging with regard to Fast and
Yes,
Furious?
comments that were made, how you were going to message it, any of that.
Well, we have certainly talked about the way in which we could deal with the interaction between the Justice Department and Congress, about ways in which we would...
But nothing about press messaging at all?
Well, I mean, in terms of trying to get a message out that was consistent with the facts and make sure that it was done in an appropriate way. I've had conversations like that with people in the White House counsel's office.
Just 2 other quick questions. I know that you filed actions against Arizona, South Carolina, Utah, and Alabama, all Republican governors. My time is out. Would you give us a list of any similar actions of the similar profile you filed against any Democratic states with Democratic governors? And also the final thing is, if you'll let us know if you had any relationship or meetings with the White House and members of the campaign about any of the messaging or any of these actions that took place on that. And, Mr. Chairman, my time has expired. And,
thank you, Mr. Forrest.
One thing, with regard to the question of the governors, I'm not sure that there has been a photo ID attempt made by a state run by a Democratic governor.
No, I wasn't asking about photo IDs. I think if you look at these states, they were regarding, I think, immigration policies. But any action that you've taken against a Democratic governor of a similar high profile with an investigation.
Well, I'd say with regard to the immigration laws, as I understand, and I'll have to check, but I don't think that there has been a similar immigration attempt made by states run by Democratic governors, which would be the reason why we've not opposed them. But I'll check and we'll share that information with you.
And also, Mr. Attorney General, when you check, if you'd make sure you let us know the contacts you have with Mr. Axelrod regarding any messaging or anything that might come regarding those actions. Thank you.
Okay, thank you, Mr. Forbes. The gentlewoman from Texas, Ms. Jackson Lee, is recognized for questions.
I thank the chairman, I thank the ranking member, and I certainly thank the Attorney General for his service. I just wanted to add what I don't think very quickly was in the introduction of the Attorney General, and then my series of questions, Mr. General, without any disrespect, will be bullet-like, not toward you, but questioning so that I get a series of questions in. But I did note that you were a Deputy Attorney General under the Bush administration. You continued to serve, I think, through the time that you were appointed under President Obama. Is that correct? Did you remain during that time?
Yeah, little known fact, I was George Bush's first Attorney General.
I think that should be made clear for the record, because you've had a continuous public service commitment. You were in the private sector for a moment, but between a judgeship and the Superior Court, that I understand you were appointed by President Ronald Reagan at that time. Is that correct, Mr. Attorney General?
That's correct.
Let me thank you again for your service and ask a series of questions. I will be giving to you today, June 7th, a letter to ask for the investigation of the state of Texas for its purging of 1.5 million voters. I encourage and hope that there will be a speedy review inasmuch as that we're in a process of election and a November 2012 election. And I do want to just ask this question on this issue of voting, and my good friend from California wanted to establish certain rights of egress, ingress, but the protection of access under the First Amendment. And I want to just focus, if you wanted to petition your government and use no government ID, most could either take their vehicle, hitch a ride, but they would not be totally prohibited from exercising that constitutional right. And you made a point about fundamental right, but if you are denied the right to vote, there is no alternative, is there not? There's no other way. Maybe you can get a bullhorn in the middle of the street, but there's no way that you could impact the choice of those who will govern. Could you just be very quick on that answer, please?
No, I think that's right. If you want to directly impact governmental policy, who is setting those policies, that is directly tied to the ability to vote, to cast a ballot.
So do you believe it is a legitimate duty, action of the Division on Civil Rights of the Department of Justice operating under existing current law to assess issues of purging or the impact of the voter ID law?
Absolutely. We apply the law that passed by this Congress as early as 1965, reauthorized as recently as 6 years ago, overwhelmingly by Congress.
Are you going outside the bounds of the law when you, in essence, review Florida or Texas or Ohio or Indiana, the case preceding the Indiana case? Are you outside the boundaries as you can assess?
All we're doing is applying the law that exists and has existed for over 40 years now.
With respect to the Affordable Care decision, which is pending, but I just want a simple question. Do you feel that there was a adequate review and the decision ultimately rested with the Supreme Court, which I think has done a decent and fair job on recusals with respect to Justice Kagan? Could you have done anything more than what was appropriately done by the Justice Department?
With regard to the recusal issue?
Yes.
No, I don't think that we should have done any more. The question of recusal, I think, is something best brought up by the litigants in the case. They had that opportunity. I don't know if they raised it or not, but I think the Justice Department has done all it can, certainly responding to FOIA requests, and all information that I think appropriately can be shared has been shared.
I appreciate it. We are certainly saddened by the loss of life that was resulted by the Fast and Furious. I think you have said that often. Are you aware of the report produced by Ranking Member Elijah Cummings?
Yes.
Were you aware that do you believe that under this report that his staff and Ranking Member Cummings of the Oversight Committee extensively reviewed either the 7,600 or at least the whirl of information that was given?
Yeah, I think they did a good job of reviewing the information. They produced a good report that contains a number of reforms that we have tried to implement.
Quickly, the statement says that they found no politically motivated operation, that the Fast and Furious was not conceived and directed by high-level Obama administration political appointees at the Department of Justice. Would you concede that they would have the basis to say that?
I think if one looks at the documents, that statement is manifestly true.
Can I ask you as well to investigate, and are you concerned or have you seen the impact of single race-based juries in a number of cases? This has been an issue in a number of areas, particularly in the South, in cases that are particularly sensitive. I'm going to ask you to investigate the Chad Holly case, which is a beating incident that occurred in Houston, Texas, and the series of trials that are coming forward, but in particular, one case was tried by a single race jury and, of course, resulted in the acquittal. Would you please take this as an official request for the Justice Department to investigate the beating and the resulting trial that was a single race jury in the case of Chad Holly?
I mean, the Supreme Court has recognized that the selection process, that a deliberate attempt at creating a jury of a single race under the Batson case is not appropriate. I'm familiar with the Holly case, not intimately familiar with, but I am familiar with the Holly case, and that is something that we are in the process of determining what course of action we should take.
Mr. Attorney General, a number of members today have made requests from you of information. When can they expect those requests to be responded to? Within 2 weeks or so?
We will do the best that we can as quickly as we can. I'm a little surprised that we have not responded at least to some of the things that have been raised in connection with the last time that I was here, but we will try to do a better job than that.
Okay, thank you.
I thank the chairman. Thank you, Mr. General.
Thank you, Ms. Jackson-Lee. The gentleman from Iowa, Mr. King, is recognized.
Thank you, Mr. Chairman. Thank you, Attorney General, for being here to testify today. Just in picking up on the chairman's remarks, I'd point out that I had a series of questions that I asked December 8th here. And although we haven't pressed relentlessly for those responses, I haven't seen them. And so I'm going to be submitting a new request from December 8th and then additionally here for this today, I believe. But I think, first of all, there's one piece left on the Fast and Furious I'd just ask you is that can you tell me when you first started to doubt that the original letter was inaccurate? Can you tell me what piece of information caused you to do that?
Yeah, I mean, I think my first doubts happened just before or just about the same time that I asked for the Inspector General to conduct a report. As I listened to media reports and things I was getting from Senator Grassley, that's when I think my doubts first began about the accuracy of the February 4th letter.
Was there a piece of information, though, in particular in those media reports that caused you to doubt, or just the information itself? You thought you had to look into it?
I'm not sure I can remember anything specific, but I do remember that the reports were inconsistent with what I was hearing from people within the department and also inconsistent with what Senator Grassley was telling me in a letter I think that he sent to me like on February the 9th or something like that.
Okay, yeah, I've got a February 4th letter denying ATF ever walked guns. That was 2011. I don't have the date of Senator Grassley's letter, but that letter was formally withdrawn on December 2nd, 2011. That's consistent with your testimony, though, I recognize it, and I thank you. And then I take us back to the Pigford issue and the discrimination issues that we discussed the last time, General Holder. And now we discussed Pigford then, and I posed the question that in the Farm Bill of 2008, consistent with, I believe, your testimony and also a statement made personally to me by Secretary Vilsack, that the Farm Bill authorized the negotiations in the agreement that ultimately lays out in the terms of $1.25 billion to be distributed to black farmers who have claims of discrimination. And the authorization within the Farm Bill is $100 million, and that's to cap that for all of the settlements that are there. And now I see that not only is it not capped at $100 million, it's been expanded and to $1.25 billion. And we have 3 other cases out here since that period of time: Garcia versus Vilsack, Keepsiegel versus Vilsack, Love versus Vilsack. And when I total them up, it's $1.33 billion in this order, Garcia, $760 million Keepsiegel, $1.33 billion Love, coincidence I suppose, $1.25 billion Pigford, for a total of altogether $4.93 billion in poised to either having been distributed or poised to be distributed under these discrimination cases. A lot of it, $3.58 billion, coming out of the Judgment Fund. And can you tell me how much is in the Judgment Fund? And I'm going to ask you to produce a report of the funds that come in and the funds that are distributed out of the Judgment Fund. I think this Congress needs an oversight if we're dealing with numbers that are approaching $5 billion.
What I can say is that the settlements that were reached, we set pools of money that can be tapped if people can prove that, in fact, they were discriminated against. There is certainly an unfortunate history of discrimination that I think everybody acknowledges exists between the Department of Agriculture in dealing with farmers of a variety of ethnicities and genders. And the attempts at structuring these settlements was to deal with, to redress those wrongs.
But $5 billion in round figures, $4.93 billion, that is a big chunk of money to be distributed without congressional oversight. And do you have any resistance to Congress taking a look at that data, the contingency fees and the distributional amounts and the sources of that money and the amounts?
No, I mean, I think that's a legitimate oversight to talk about the way in which the cases were settled, how it impacts the Judgment Fund.
Thank you. Then I'll follow up with a more specific question, but I wanted to also ask you about your reaction when you saw the video of the young man who claimed your ballot here some months ago, and your reaction towards a requirement for a photo ID after you saw that video.
You know, I mean, it's an attempt to show something, I suppose, but I think what I drew from that video was that that guy was very careful not to say he was Eric Holder, not to actually get a ballot. He didn't do the kinds of things that would have subjected him to criminal process.
Yeah, and I'm not worried about that, but he could have obtained your ballot with ease. It was offered to him. And so I just suggest this, that it may not be impossible, but I think it's been determined here today in the questioning of Mr. Lundgren that visiting a federal building, even your building, is maybe not impossible but difficult without a picture ID. And if it's difficult or impossible to visit a government building without a photo ID, then how can we allow someone to help choose our government without a photo ID?
Well, but you see, I think the question is, if you look at, for instance, South Carolina, they had in place measures that protected the integrity of the ballot before they went to the photo ID. And I don't per se say that photo IDs are necessarily bad. The question is how the structure is put in place, how they are distributed, whether or not it has a disproportionate impact on people of a certain race, certain ethnicity, certain age group.
But why would it?
The gentleman's time has expired. Thank you, Mr. King. The gentlewoman from California, Ms. Waters.
Thank you very much. We'd like to welcome you, Mr. Attorney General. I had a number of questions I wanted to ask you, but my attention has been diverted to the line of questioning from Congressman Goodlatte. It is well known that you dismissed the charges, Stevens, that were placed against Senator Stevens following your investigation that indicated that certain exculpatory evidence had been withheld. Now, was there just one thing, or were there several things that were done that you disagreed with that caused you to dismiss?
The thing that was the main motivator for my decision to dismiss the case was I thought the pretty solid evidence that we had uncovered that Brady material, exculpatory material, had not been shared with the defense. And I think that was the basis, the main motivation for my deciding to dismiss the case. And
it seems that I think his name is pronounced Mr. Schuelke,
Yep.
S-C-H-U-E-L-K-E.
Hank Schulke.
Agreed with you, basically. But the punishment now does not seem to match the crime, prosecutorial misconduct. And a lot of people are wondering, how does the Office of Professional Responsibility literally dispute the seriousness of the withholding of the exculpatory evidence? How do you account for that?
Yeah, I wouldn't agree that they don't take it seriously. I mean, Mr. Schulke, who I know and respect, is a good lawyer, came up with a report and said that he thought that the material was withheld intentionally. The OPR report, which is like about 700 pages long, says, yeah, the information was withheld, but said it was done recklessly, not intentionally. And it was on that basis that the OPR recommendation was made as to what the appropriate sanction was. Mr. Schulke never made a recommendation as to what he thought the appropriate sanction should be, because I think, as Judge Sullivan said, there was not an order that he could actually point to so that he could find contempt or something like that. So I think that's the difference between the Schulke report and the OPR report, the state of mind of the person who was engaged, who did not turn over the information, or people who didn't turn over the information.
So in your opinion, do you believe that the recommendations for punishment by the Office of Professional Responsibility, are those recommendations basically in line with the unintentional withholding, or perhaps it could have been stronger? What do you think?
Well, I think it's appropriate for the Attorney General not to comment on these determinations, because it is something that is not my responsibility to do. We put that in the hands of the career people. We have a great OPR, a great Office of Professional Responsibility. We have a structure in place so that people outside of OPR look at the findings of OPR and then make a determination as to what the appropriate sanction should be. And the people who are political in nature are really insulated from that process.
So I suppose what we can conclude is that you dismissed, you felt that the withholding of the information was serious enough to dismiss.
Yes.
And that whether it was, and I asked, I think earlier, was there leaking of information? Was there sharing of information with others that it should not have been shared with, in addition to the withholding of information?
No, I don't know. As I remember it, the concern that I had was with the non-providing of information that the defense was entitled to. That was the concern that I had.
And so clearly, you addressed that concern, but again, after having addressed it, the Office of Professional Responsibility had the responsibility to determine what the punishment should be, and you have no hand in that. Is that right?
That's correct.
Okay, well, I just wanted to get on the record that the withholding of the evidence was a serious matter, and that you made a decision based on that.
No, I would agree with you. Whatever whether you agree with Mr. Schulke or with OPR, whether it was intentional or reckless, negligent, it was serious, and I think necessitated the dismissal of the case, which is what I did.
Thank you very much. I yield back the balance of my time.
Thank you, Ms. Waters. Does the gentleman from Virginia, Mr. Scott, have unanimous consent request?
Yes, thank you, Mr. Chairman. Mr. Chairman, I ask unanimous consent to enter into the record letters from the National Organization from Black Law Enforcement Executives, City of Philadelphia Police Department, Boston Police Department, and Association of Prosecuting Attorneys on behalf of the Attorney General, and also a copy of the draft contempt citation. We were questioning what had been asked for. Draft contempt citation offered by the Committee on Oversight and Government Reform, which says in part, the wiretap applications document extensive involvement of the Criminal Division in Fast and Furious, yet the Department of Justice has failed to produce them in response to the committee's subpoena, so that we know exactly what was asked for.
Without objection, those documents will be made a part of the record. And the gentleman from Arizona, Mr. Franks, is recognized for questions.
Well, thank you, Mr. Chairman. Thank you, General. Mr. Holder, on April 27th, 2011, members of this committee asked you to give us information surrounding the decision by Justice to forego prosecution of the unindicted co-conspirators in the Holy Land Foundation case. This is the largest terrorism finance case, of course, in U.S. history. Now, you refused to comply with this request, and you've still not you're still not prosecuted, despite there being what many consider to be a mountain of evidence against these jihadist groups, at least one of which now says that it's working inside your agency to help advise on the purge of counterterrorism training materials. And we're told that this mountain of evidence, which outlines the jihadist network within the United States, amounts to 80 bankers' boxes full of documents. This evidence was turned over to the court, and much of it was given to the jihadist defense lawyers. And members of this committee and other committees would like to review this evidence, whether it has to be on a classified basis or not. Would you commit today to give us and provide us with those documents which comprised the government's case in the Holy Land Foundation trial?
It's hard for me to answer that question. I don't know.
No, it's not. It's not hard to answer. It's just will you or will you not?
I don't know what the nature of the evidence is. I don't know if it's grand jury material. I don't know if it's wiretap information. I mean, there are a variety of things that I'd have to look at. I can certainly take your request, and we can check to see what the nature of the evidence is and make a determination about whether it's appropriate for that material to be reviewed. I just don't know.
All right. Well, we made the request on April 27th of last year, and so far it hasn't happened. So I would like to make the request, and would you give us your best efforts basis, that your good faith effort, that you will give that information to us if you can do so?
I'll certainly make a good faith effort to look at the request that you've made and see whether or not it can be complied with.
All right. Well, I guess I would hope that you would also give us some explanation as to why the request has been ignored thus far. Let me shift gears on you here. It's been reported that multiple agencies, including the FBI, are now purging counterterrorism training materials of information outside groups might find offensive, including discussion of things as fundamental as that, quote, Al-Qaeda is a group that endorses violent ideology that should be examined, unquote. That's one example. Per the new guidelines, FBI agents may no longer discuss this in their training sessions because it offends some people. And it's been purged. And this strikes many as the sacrificing of vital national security, the muzzling of our national security apparatus on the altar of political correctness. And this concern, I think, General, seems warranted, given that the bipartisan Senate report on the Fort Hood massacre, to quote them, the worst terrorist attack on U.S. soil since 9/11, found that, quote, political correctness inhibited officials from taking actions that could have stopped the attack. Now, members of multiple committees are now investigating. Has anyone inside your agency coordinated with any other federal agencies, such as DOD or DHS or the Department of State, to carry out this review of counterterrorism training materials?
Well, let me say first off that the decisions that were made by the FBI with regard to what use would be made of certain materials is not based on political correctness or whether or not something is offensive. The search was for materials that were simply incorrect, that stated, had assertions about particular things that were simply wrong, and didn't think that was appropriate to be included in the training materials. Bob Mueller has taken this very seriously, but I can tell you, I mean, if anybody knows Bob Mueller, he is not making the determinations on the basis of what is either offensive or politically correct. That is not the driver in this attempt to make sure that our training materials are accurate.
So has anyone inside your agency coordinated this effort, such as it is, whatever it might be, with DOD or DHS or the State Department?
Well, I'm not sure that we necessarily have to. We obviously interact with our partners all the time in a variety of ways. The Deputy Attorney General issued some guiding principles to all DOJ component heads and U.S. attorneys to make sure that these training materials were accurate. We interact with our partners all the time, and it is on that basis, among other things, that we have an ability to decide what materials are accurate.
Well, so one of two things. Either your position is that no one in your agency has spoken with or met with other agencies or the White House in carrying out this purge of vital counterterrorism materials, or they have. And if they have, who directed these agencies in general to purge these materials? And what outside groups are advising the department on the issue?
This is an internal process being done by members of the FBI, members of the Justice Department, who are steeped in this.
Can you tell us what outside groups are advising you on this process?
This is something that's being run primarily out of the FBI. I mean, to the extent that there are outsiders who are involved in this war, we are trying to interact with. I mean, we can try to get you those names.
I'll leave it right there. I'll just respectfully, officially ask you to give us the list of who the outside groups are that are working with you on this process, because one of them is a jihadist group that says they are working with you on it, and I just want to make that.
I don't believe that's accurate, but I will relay the request to the FBI.
All right, thank you, Mr. Chairman.
Thank you, Mr. Franks. The gentleman from Illinois, Mr. Quigley, is recognized for questions.
Thank you so much, Mr. Chairman. Sir, it is, as you know, very hard to minimize or diminish the tragedy that is Fast and Furious. Horribly ill-conceived program that led to the loss of life of an agent, endangered others. And as you agree, there must be a continued, thorough, independent investigation. Justice must be done. Corrections must be made, and I believe have been made. But with the greatest respect, I would say today that I believe that the effort here has become politically motivated in an attempt to embarrass the administration. And that diminishes the process. The operative phrase that comes to mind, since bad witness has been used, is pay no attention to the man behind the curtain. Mr. Attorney General, welcome to Oz. Pay no attention to the fact that this process began under a previous administration. Pay no attention that the agencies lack sufficient resources. Pay no attention that the head of the ATF hasn't been allowed to be appointed. Pay no attention that the laws are inadequate to protect agents and citizens on both sides of the border. Even more specifically, that in Arizona, any citizen may purchase an unlimited number of AK-47s and transfer them within the state in private sales. That the special agent, Peter Forcelli of the Phoenix Field Division, testified at a previous hearing that as it relates to straw purchasers and punishments, he used the expression, quote, "Some people view this as no more consequential than doing 65 in a 55. And that as it relates to the gun show loophole, we recognize the fact, and others would ask you to pay no attention, that you can buy any type of gun you want without any background check. You could be adjudicated as dangerously mentally ill, you could be a felon, you could be on your third order of protection, you could be on a terrorist watch list, and you can buy what you want. In terms of resources, the Washington Post said in 2010 the ATF has the same number of agents it had in 1970, while the FBI has grown by 50% and DEA by 233%. I'm glad those agencies got the growth they need because they make us safer, but ATF does as well. And finally, pay no attention to the fact that Special Agent Peter Forcelli of the ATF said, "I have less than 100 agents assigned to the entire state of Arizona." That's 114,000 square miles. Do we have the resources? No, we don't. End of quote. We desperately need them. So, Mr. Attorney General, life is, unfortunately, even after tragedies, about moving on. And I ask you, in a perfect world, what are the situations and resources that you and other agencies have to combat the threats that are still going on, the fact that people are still dying from gun violence in the border area?
Yeah, it is an issue that we have to confront. Recent studies have shown that of the 94,000 guns that were seized in Mexico, 64,000 of those guns can be traced back to the United States. I think there are a number of steps that Congress could take and help us in connection with this fight. We need a comprehensive firearms trafficking statute. We need tougher sentences for straw purchasers, so you don't have that 65, 55 mile an hour thought. We need to give ATF the resources that it needs. In fiscal year 11, Congress cut our requests for 14 Project Gun Runner teams in half. It decreases our capacity to do these kinds of things, and I think that Congress should not attempt to block the long gun reporting requirement that has recently been upheld by a federal court that would require somebody buying multiple AK-47s over a 5-day period to have that information simply shared with the ATF. That is a valuable intelligence tool and has helped us, while it's been in place in only 4 border states, to develop leads and deal with the situations that you have described.
And if I might switch gears briefly, I come from Illinois, I come from Chicago. It's important to recognize the gentleman stepping down from the Attorney General's position in Chicago has left an extraordinary legacy. I want to commend his efforts, and I'll give you the opportunity to do the same, if you will.
I have known Pat Fitzgerald since he was a line lawyer in the Southern District of New York and working on really consequential, important terrorism cases. I have admired his work then. He has been an outstanding U.S. attorney in 2 administrations. He is a true patriot. He has been a great U.S. attorney. He has focused on public corruption matters as well as national security matters. He has, in fact, been a model U.S. attorney and somebody who's going to be sorely missed by us in the Justice Department.
Thank you, sir. I yield back.
Yeah, okay. Thank you, Mr. Quigley. The gentlewoman from Texas, Ms. Jackson Lee, is recognized for unanimous consent request.
Mr. Chairman, thank you for your courtesies. Unanimous consent to submit into the record a report of the minority staff of the Oversight and Government Reform dealing with Fast and Furious. As unanimous consent, a statement on the draft contempt citation of the Oversight Committee, a letter regarding the purging of voters, and a letter regarding race-based juries. Ask unanimous consent to submit it into the record.
Reserving the right to object.
The gentleman reserves the right to object and can be heard on his objection.
I have no objections to the latter material, but in the case of the former material, I would ask unanimous consent that if we're going to enter one side of any document from another committee, if you want it into the record, that corresponding documents be allowed to be prepared in so as to give a complete report.
Okay, with that objection, the documents mentioned by the gentlewoman from
And I have no
Texas
objection.
will be made a part of the record, and the documents referred to by the gentleman from California will be made a part of the record. We'll now go to the gentleman from Texas, Mr. Gomert, for his question.
Thank you, Mr. Chairman. So you know where I'm coming from, Mr. Attorney General. I've been a prosecutor. I've been a district judge handling felonies, including death penalty cases. I've been a Chief Justice of a Court of Appeals. I've been appointed to defend cases I didn't want to defend, but I did my very best job and did it well. I've had people come before me who were friends that I've sent to prison because that was consistent with justice of what I would have done to someone in their situation who was not a friend. I have sentenced the children of friends with a courtroom full of my supporters who were all begging me not to, but I knew if I was going to be consistent in justice, I had to do that. I've sent people to prison because it was the fair and just thing when considering all of the facts. and considering what had been done in the past. And then I've gone in my office after sentencing and wept because of the personal anguish of those that I care deeply about. But I knew I did the right thing, and history has borne me out. So when I hear an Attorney General of the United States come before us and say, somewhat cavalierly, there is a political aspect to this office, it offends me beyond belief. Your job is justice, Mr. Attorney General. It's justice across the board. And that is what's been so troublesome around here. When we made a request a year ago here for the documents that your department has produced to people who were convicted of supporting terrorism. They're terrorists. And we wanted the documents you gave to the terrorists. We're a year later and we still don't have them. Why in the world would your department be more considerate of the terrorists than of the people who are members of Congress who can vote to just completely defund your department? It makes no sense. So I will ask again, and there is no room for a response that, well, it's an ongoing investigation, well, some of these may be classified. I'm asking for the documents your department produced to the terrorist supporters convicted in the Holy Land Foundation trial. Can we get those documents, just the ones that you gave to the terrorist defendants?
Well, certainly you can have access to those things that are on the public record that were used in the trial. I was also a judge. I sat in this Washington, D.C.
So is that a yes or a no that we will get those documents?
As I said, I was also a judge and understand the anguish that you go through. And just clear up one thing with regard to the political aspect of this job. I have to advance or try to advance legislation that I think is appropriate for the department. That is a political job. I push policy initiatives for the department. That is a political component. I fight defunding requests that people kind of cavalierly throw around about the budget of this department. That is, from my perspective, a political component to this job.
Sir, it is not cavalierly. When a department has parts of it that are not doing their job, and in fact may be giving more aid and comfort to people who are part of organizations who want to bring about an end to our way of life, then that concerns me that perhaps that is an area that should be defunded. And when you've been here before and we've talked about Fast and Furious, and you were asked who actually authorized Fast and Furious, you had said, we may not ever know who authorized Fast and Furious. Are you any closer right now as you sit here to knowing who authorized Fast and Furious?
I suspect that we are closer given the fact that the Inspector General that's charged with the responsibility of investigating this matter at my request has been in the field and been interviewing people, and my guess would be that we are closer to that. I would expect that report will be out relatively soon.
Did you not ever go back to your office and say when you found out about Fast and Furious, I demand to know who authorized this? Are things so fast and loose in your office that somebody can authorize the sale to international criminals of American guns that are bringing about the death of even American agents, and nobody has to do that in writing?
The gentleman's time's expired, but you can answer the question.
Well, let's look at what I did do. I asked the Inspector General to conduct an investigation. I put an end to the policy that led to the Fast and Furious debacle. I made personnel changes at ATF and in the U.S. Attorney's Office. We made changes in the procedures there. And that's in stark contrast to what happened to my predecessor, Attorney General Mukasey, when he was briefed about the transmission of guns to Mexico, and as far as I can tell, did far less than what I did.
So that was a
if you want to
different
look at what
aspect.
I did, if you want to look at what I did, those are simply the facts.
My question, though, Mr. Chairman, was, did you go back and say, I demand to know who authorized this Fast and Furious program? That was the question. Pretty simple.
That's consistent with me telling the Inspector General, find out what happened here. So the answer to your question is yes.
The gentleman's time has expired. The gentleman from Georgia, Mr. Johnson, is recognized for 5 minutes.
Thank you, Mr. Chairman. On May 12th, the House passed its Commerce, Justice, Science Appropriations Bill. And this is a part of the Ryan budget. And it tries its best to eviscerate and neuter the ability of the Justice Department to protect Americans as it is supposed to do. You can't operate without money, and the bill, in its attempt to neuter the department, cuts funding for financial and mortgage fraud enforcement. It prohibits funding for enforcing the requirement that licensed firearms dealers report multiple sales of rifles to the same person. It prohibits funding to bring actions against states for their voter identification laws. Among other things, the bill would cut funding for the general administration line on the DOJ's budget request from $81 million to $45 million. Excuse me, yes, $29 million less than requested. The DOJ program for rescissions and asset forfeitures has been cut. The number of U.S. attorneys, you'll have 1,000 unfilled positions, and you've already lost, and that's attorneys. You've already lost 850 staff since the hiring freeze that was instituted in January of 2011 has gone, since that went into effect. And this bill could result in an additional 411 positions lost. The Antitrust Division is cut $5.2 million. You could lose up to 70 positions in that unit. You've already lost 77 positions in that unit. That's the unit that keeps consumer prices low and gets at collusion and bid rigging and other activities that cost money to consumers, cost consumers money. The U.S. trustee program, which you administer, which is so important in bankruptcy, which are on the rise. They've seen a 5% reduction. 50 positions may be suspended. Law enforcement wireless communications for the department has been cut. The ability to hire people in foreign language, skilled in foreign languages, has been cut. These things hurt the department's ability to be effective. I want to get to that part about the voter identification laws. You were answering a question that was posed to you by Mr. From Iowa, Mr. King, but you were cut off by the bill and you were not given a chance to complete your statement on that. Can you complete it now, please?
I'll be honest with you, I don't remember where I was.
Well, it had to do with the South Carolina challenge of your department to their voter ID laws.
All I can say is that with regard to the South Carolina law, we looked at the evidence that was provided to us by South Carolina. did not feel that the evidence about voter fraud was substantial enough to overcome the disproportionate impact that the changes in their voting procedures had on minorities, older people, young people, and it was on that basis and under Section 5 of the Voting Rights Act that we decided to file suit, well, to not pre-clear that which they had tried to do.
So basically you were stating, or you've stated, that the reason that South Carolina gave for making it tougher to vote through voter ID requirements, the reason that they did that, which is to get at voter fraud, did not hold any water. In other words, there was insufficient evidence of voter fraud, and so therefore there must have been some other intention behind their legislation to make it more difficult to vote. Would you agree with me on that?
Well, the initial material that we got from them did not have any statistical proof. We got a submission from them later on that indicated there were perhaps 900 people who had, I think, who were dead, who were on voter rolls or something along those lines. That was then disputed by another South Carolina official. I mean, this is all a matter that is now before the court and will be ultimately decided by a court here in Washington, D.C.
And then, as I stated earlier, the House Commerce Justice Science
Gentleman's
Bill
time has
prohibits
expired.
funding to bring actions against states for their voter identification laws. And I'll yield back the balance of my time. But I would like to make a unanimous consent request.
With that objection, what document does the gentleman wish to enter into the record?
There are 10 letters of support for Attorney General Holder, praising his leadership from the National Fraternal Order of Police, from Patricia Meisch, the Tucson shooting survivor, a letter from the Leadership Conference to Chairman Issa, a letter from Commissioner Ramsey to Chairman Issa, a letter from the National Action Network to Chairman Issa, letter from the Leadership Conference to Speaker Boehner, a letter from the National Women's Law Center to Speaker Boehner, a letter from the National Women's Law Center to Chairman Issa, a tri-caucus letter from Representative Gonzalez, Representative Cleaver, and Representative Pugh.
With that objection, all those letters
And last
will be
but not least,
made
a letter from the National Organization of Black Law Enforcement.
Did you get these letters from the Attorney General himself? No, I'm teasing that. With that objection, all those letters will be made a part of the record.
Thank you, and I yield back.
The gentleman from Texas, Mr. Poe, is recognized for questions.
Thank you, Mr. Chairman. Thank you for being here, Attorney General. I want to thank your office for the cooperation they've had on this specific issue of human trafficking, the new scourge that's happening in the United States. Recent Pew study has come out and said that there are approximately 2 million ineligible voters in the United States. Of that 2 million, 1.8 million are dead people. I would assume you would agree that voter rolls, when verified that the folks on the rolls are dead, they should be purged in some manner. Would you agree with that or not?
Absolutely. I think the purging should occur. It just ought to be done consistent with federal law.
Your office, how many specific cases have you prosecuted, or your office has prosecuted, on voter fraud since you've been Attorney General?
I don't know what the number is. I know that I prosecuted them myself when I was in the Public Integrity Center.
But just when you've been Attorney General?
I don't know what the number is.
Would the number be 0?
No, I think that we have had vote fraud cases that I know that we've either settled through pleas. I'm not sure we've had trials, but I know that we've had cases where people have committed offenses where they've made straw donations and other ways in which voter fraud was carried out. I know we've done those cases. I don't know what the numbers are.
Okay, so that I know the exact number, because the information I've been given, it's 0. So if you would provide me the actual number, I don't need the cases, just the number of cases that your office has prosecuted under Section 8 of the law, and let me know, and let the chairman know the exact number, because, like I said, my information is there are none.
Well, I mean, our efforts to fight voter fraud, though, go beyond just Section 8 of the NVRA. There's a whole range of other statutes that we use in bringing those cases.
I would like to know specifically Section 8 prosecutions under your term as Attorney General.
Okay. We can wrap that into the larger
I know there are other cases.
what our effort-
I'm not asking for the other ones. Just to be specific, I'm asking for the Section 8 prosecutions by your office.
I mean, but just to be fair, to get a sense of what it is we're doing, as I said, we'll give you that information, but as I said, I will give you a sense of
You
what
can
we're
give
doing
me
in
more
the county.
information if you wish. That's fine. Just so it's Section 8's included in that. That would be great.
Sure.
The Mexican ambassador to the United States recently has made some comments about Fast and Furious that Mexico was unaware of, to quote, Mexico was never apprised how the operation would be designed and implemented, talked about the fact that Fast and Furious has hurt the relationship between the United States and Mexico. I'm not surprised that he would say something like this. We constantly talk, as we should, about the Americans that were killed in Fast and Furious, but there were apparently, according to in the Mexican news reports, hundreds of Mexican nationals killed because of Fast and Furious. The last time you were here, you answered a question and you said more people will probably die because of Fast and Furious. Do you know how many people in Mexico have been killed as a result of the United States helping to facilitate straw purchases of automatic weapons going down to Mexico? Do you know how many?
I don't know, but I would think that there have been some, and I know that given the 64,000 guns that have gone from the United States to Mexico, that Mexican citizens, Mexican law enforcement officers have lost their lives as a result of guns that started in the United States but ended up in Mexico.
How many of the guns have been recovered of the total number in Fast and Furious? And get different numbers. I've heard 1,200, heard 2,000. How many guns have been recovered in Mexico that were the result of guns involved in the Fast and Furious operation?
I don't know that number.
Any guess at all? Do you know? I mean, that was the purpose, was it not, of Fast and Furious, to sort of keep up with the firearms when they go to Mexico and see where they were used in a crime scene and then who the bad guys were? Wasn't that sort of the purpose?
Yeah,
Veiled purpose?
That was the stated purpose, as it was in Wide Receiver and the previous attempts at dealing with the flow of guns from the United States to Mexico, none of which were ultimately successful, and all of which allowed guns to be inappropriately put into the stream of commerce.
How many guns have been recovered on Fast and Furious?
I've heard different numbers on that as well, anywhere from 800 to 1,200. I just don't know. I think we start off with a number of about 2,000 that will put inappropriately put into the stream of commerce, and then the number that has recovered, as I've heard, 800 to 1,200, but I don't know.
What would America's reaction be if the roles were completely reversed? That if our neighbors, Mexico or Canada, they smuggled, facilitated the smuggling of automatic weapons into our country, where Americans were killed, Mexican nationals killed, what would be our reaction to that as the head lawyer in the country?
Probably similar to what the ambassador has said, though I do have to say that we maintain a good relationship with Mexico that operates on a whole bunch of levels. Certainly law enforcement is the one that I'm most familiar with. I have a good relationship with the Attorney General in Mexico. We talk all the time, and we continue to work together on a variety of law enforcement projects, and it's not been deterred by the regrettable Fast and Furious episode. But I can understand the Mexican ambassador's comments.
And what are we doing to wrap the operation? Oh, I'm sorry, Mr. Chairman, I didn't realize. If we're from the South, we should get more than 5 minutes, I think, Mr. Chairman.
I think so
we
too.
talk slower.
Why doesn't the gentleman from Texas ask a question that he'd like the Attorney General to respond to in writing?
Then I ask unanimous consent to submit. You may ask the question or submit the question in writing. I'm sorry.
I was going to suggest you ask the question you were planning to ask, and we'll get the response later on.
I will submit the numerous questions to the Attorney General. He'll submit back, if he would, to the chairman. Thank you.
All right. With that objection, thank you, Mr. Poe. The gentleman from Tennessee, Mr. Cohen, is recognized.
Thank you, Mr. Chairman, and I'll talk fast, even though I'm from the South. Mr. Attorney General, we appreciate your coming before us. In October 2008, the Department of Justice approved the merger between Delta and Northwest Airlines. The Department of Justice issued a statement. You may not remember this. quote, the proposed merger between Delta and Northwest is likely to produce substantial and credible efficiencies that will benefit U.S. consumers and is not likely to substantially lessen competition, unquote. Unfortunately, that forecast has, in many people's minds, in Memphis in particular, proved to be grossly inaccurate. Many of the promises made by Delta in front of this committee have been broken. As anybody in Memphis can attest, the price of flying out of this quote-unquote fortress hub is much, much, much higher than it is flying out of other cities. And you can fly to cities through Memphis at cheaper prices than you can from Memphis to X. If you go from another city through Memphis to the city, it's cheaper than Memphis to. This has caused the city the loss of conventions, the loss of businesses who said we left Memphis because the price of flight in and out was too great, so they moved to Atlanta. A convention moved to Kansas City. Another group moved to Kansas City. People in Memphis are very upset about this, and we have unreasonably high airfares. Memphis is not alone. Cincinnati lost their hub, and service has been cut in Minneapolis as well. Now that the merger is in place, what type of enforcement mechanisms does your Department of Justice have to ensure competition or to try to get competition and break up what is in essence a monopoly?
Well, I think that we have been appropriately aggressive in our antitrust enforcement efforts. There are a number of cases that we have brought, everything from e-books to the way in which telecommunications industry has tried to consolidate. And in those cases where we have not brought suit, we have extracted from the parties who have sought to join promises or concrete divestitures of assets so that we would maximize the chances that the consumer would benefit. I think we have focused appropriately on what the impact will be on consumers, and I think that the...
But in the airline industry, have we done anything? Because the airline industry has gotten to be basically three major carriers. They've divided up the middle cities, and the middle cities are hostages. They are company towns, and the people in the cities have to pay whatever they're charged.
Yeah.
Can we do anything about that?
Well, I mean, there's a certain amount of consolidation that has happened in the industry that I think is necessary for the survival of those companies. But, for instance, you look at what Delta and US Air tried to do in transaction involving LaGuardia Airport and National Airport here in Washington, D.C. We approved what they wanted to do in New York, and we have reserved decision on what they wanted to do here in Washington to see what the impact of these consolidated...
If I can interrupt you because our timing is limited. Washington, Los Angeles, New York, the big cities have got competition. It's the middle American cities that are getting the brunt of this. Memphis is one of them. What can you do about Memphis, Cincinnati, St. Louis, Pittsburgh?
Well, I mean, what we can always do is to examine what the impact of these mergers has been, and if we find anti-competitive operations in a particular city.
But then can I ask you to look into Memphis and the situation there? Frontier Airlines came in, Delta came in, undercut them, Frontier left. US Air now is running Memphis, Washington. Delta is going to undercut them. Southwest is not looking to come in. We talked to Southwest. They said, if we come in, we're going to be undercut. That's monopoly.
Yeah. I mean, there cannot be, I can't comment on the particulars that you, because I'm not aware of them, but to the extent that one entity tries to undercut another inappropriately by lowering its prices and driving that competitor out of the market, only to drive that competitor out of the market, and then raises its prices once the competitor is gone, that's inappropriate under our antitrust laws. And that's the kind of thing that would have an impact on consumers and that we would aggressively pursue.
Well, let me ask you to look at the situation in Memphis. That's number one. Number two, in Memphis, too, and I think I've written you about this, grocery store business. Kroger's come in and taken over the market. They bought out Schnucks, then Schnucks took Kroger's shops in southern Illinois. Schnucks has got a area of influence in southern Illinois they didn't have because they swapped stores with Kroger. Prices have gone up. There's not competition there. It's happening all over America. Business is finding ways to work with each other to create monopolistic practices and take advantage of consumers, and consumers are left off. It's what's happening. Income inequality, purchasing ability inequality, the middle class, the consumer, they've got nowhere to go. The only hope and change they've got is with you and this administration. Otherwise, big business is cutting them out. So I appreciate you looking into those monopolistic practices and looking after the consumer, which I know you want to.
Our focus is on the protection of consumers, and I think, as I said, that we've been aggressive. We put people to head that division who shared that attitude, and as I said, I think they've done a good job.
Thank you, and I yield back the proverbial remainder of my time when I have none.
Gentleman's time has expired. Chair recognizes the gentleman from Utah, Mr. Chaffetz.
Thank you.
5 minutes.
Thank you. Thank you, Mr. Attorney General, for being here. I'd like to focus my comments on Fast and Furious. You stated in previous testimony here today that you had read the 6 wiretap applications. I, too, have read those wiretap applications. I come to a conclusion that is totally different than your conclusions. And that is, but I think, a sliver of the information that we're looking at, where a reasonable person would only come to the conclusion that the senior-most people within the Department of Justice did indeed know that guns were walking, that those tactics were being used. And I guess my question for you, Mr. Attorney General, those things are sealed, those wiretap applications. Nobody wants to impede an ongoing investigation or hamper prosecution opportunities. My question for you today is, would you be willing to make yourself personally available to myself and Mr. Gowdy, and in the essence of fairness, Mr. Bobby Scott and Mike Quigley, to come talk to you, sit down, and I want you to show me how you don't come to that conclusion, and I'd like to show you why I think there's a preponderance of evidence that would lead one to believe that, yes, indeed, the Department of Justice did know about this. Is that fair? Could you make yourself available?
Well, Chairman, a parliamentary inquiry.
No,
please.
Mr.
State your
Chairman,
parliamentary inquiry.
Yeah, Mr. Chairman, I know the Attorney General is about to answer. But is it appropriate for members to refer to sealed documents in this Judiciary Committee room and suggest that the Attorney General makes a personal visit to members on what is sealed and should not be provided during a criminal investigation?
I simply ask if, again, please, Mr. Chairman, this should not count towards my time. I'm simply asking, there's a dispute here. This has gone on for a year and a half. Most members on this side asked about Fast and Furious. We're trying to resolve this, get to the end of it. It's hard to do in 5 minutes. I'm just asking for personal time to show you what we've seen and for you to share with us what you've seen.
But Mr. Chairman, I again refer, these are sealed documents. I'm trying to understand, is the gentleman wanting the Attorney General to speak to sealed documents that have been leaked and then discuss it with members while there is a pending criminal investigation? Is this the appropriate approach?
Gentleman will suspend. Gentleman will suspend. The contents of the sealed documents may not be discussed. The gentleman may have his time back and will receive the remaining time that has been allotted to the gentlelady from Texas.
Is that a reasonable request? Will you sit down with us and talk about this?
Well, I don't think that under the federal law, I have an ability to talk about, as the statute says, the contents of the wiretap information.
Would you be willing to sit with us and talk about all the other pieces of evidence that we see that aren't sealed?
What?
Well, I have sat down with you on 8 separate occasions.
I'm asking for more time to sit with you personally, more than just 5 minutes, and go through this in some depth. Give us 2 hours. Well, 2 members from the Democrats, 2 on the Republican side, and go through this.
You know, with all due respect, I give you 4 hours at a crack on 8 separate occasions. I'm not sure there's an awful lot more I have to say. But here's one point I would say. You and I have both read materials that senior people in the Justice Department, as they went through that approval process, did not read. As we know,
let me go on, please. So the answer is no.
No, but
well, you're eating up my time, and I only have about 3.5 minutes left. I'd like more time. That's what I'm asking for, and you're saying no. So please let me share with you why I think this is imperative. Sunday, October 17th, 11:07 p.m. Jason Weinstein sends an email to James Trusty. Do you think we should try to have Lanny participate in a press when Fast and Furious and Laura's Tucson case are unsealed? It's a tricky case given the number of guns that have walked, but it is a significant set of prosecutions. James Trustee sends back to Jason Weinstein. It's not going to be any big surprise that a bunch of U.S. guns are being used in Mexico, so I'm not sure how much grief we get for guns walking. It may be more like, finally, there are going to be people who sent guns, they're going after the people who sent guns down there. Now, you claim with passion that nobody at the senior levels of the Department of Justice prior to the death of Brian Terry knew that guns were walking, and I've got an email from Jason Weinstein using the term guns walking.
I think we went through this exercise before. That refers to wide receiver, not fast and furious.
That's not what the February 4th letter that was sent to the United States Congress said. It said that the ATF never uses those tactics.
And
never.
We said
that's not true.
And we said that letter was inaccurate. It was ultimately withdrawn. But the email that you just read, and this is important, that email referred to wide receiver. It did not refer to fast and furious. That has to be noted for the record.
No, it doesn't. It says Fast and Furious. Do you think we should try to have Lanny participate in press when Fast and Furious and Laura's Tucson case are unsealed? It's specific to Fast and Furious. That is not true, Mr. Attorney General. No. I'm happy to share it with you.
Yeah,
Can I ask unanimous consent to give you some extra time to review it?
That's fine. The Laura Tucson case refers to wide
It
receiver.
says Fast and Furious. We'll let the media have it and we'll play it out
Laura
there.
was not
Have
involved.
you?
Laura Duffy was not involved. Laura was not involved in Fast and Furious.
The email says Fast and Furious. You say it doesn't. I've got it in black and white. Did you personally read
I have
Speaker?
superior knowledge.
Did you personally read Speaker Boehner's letter sent to you on May 18th, 2012?
Yes, I got that.
Did you read it?
Yes.
Have you personally responded to the Speaker?
The Deputy Attorney General responded.
So you delegated that to James Cole.
I didn't delegate it to him. We thought it was appropriate for him to respond.
You didn't think it was appropriate for you to respond?
No, but what I've indicated in my opening statement, and I'm certainly willing to indicate right now, is that I am willing to personally engage with the 4 people who signed that letter and try to come to an accommodation so that we can get you the information that you need, consistent with what I think is our need to protect ongoing investigations. I want to be as flexible as we can, and as you said, get to the end.
I have a hard time buying that when you don't sit down with a guy like me and
Gentleman's
go through
time
these
has expired.
details.
Gentleman's time has expired. Chair recognizes the gentleman from Puerto Rico, Mr. Paraluisi.
Welcome back, Attorney General. And I realize it's been a long hearing. And as you say, the 8th occasion on which you appear before us. As I have stated before, first thing I'll say is that I have to commend your demeanor, your patience, your decorum in appearing before us, and in subjecting yourself sometimes to process that I do not believe is fair. If anything, this committee should always try to afford due process. And I am sad to say that sometimes here you were interrupted in a way that is not deserving to the position you're holding. So I, for one, I thank you. Now, as you probably expected, I want to complain a little bit. The familiar subject of my questioning is the federal government's response to drug-related violence in Puerto Rico and the neighboring U.S. Virgin Islands. The murder rate in Puerto Rico and the USVI is nearly 6 times the national average and nearly 3 times higher than any state. Most of these homicides are linked to the cross-border trade in illegal drugs, which is primarily a federal responsibility to combat. During your previous testimony, you stated that drug-related violence in our nation's Caribbean territories is a national security issue we have to confront. You also stated that Puerto Ricans are American citizens who deserve the protection of their government. I know you and your team have been working to address this problem. You and the heads of the DOJ's component agencies have always made yourselves available to talk to me despite your busy schedules, and I appreciate that. And there have been some major success stories in recent months, including yesterday's federal state operation, which resulted in the arrests of dozens of our airline workers in Puerto Rico who were smuggling drugs on flights to the mainland U.S. Your men and women in Puerto Rico are doing terrific and courageous work. I hope you know that I recognize and respect that. But it's also clear to me and to any reasonable observer that far more needs to be done. The CJS appropriations bill, which we approved recently this year, explicitly stated the committee is aware that efforts by federal law enforcement to reduce drug trafficking and associated violence in the southwest border region have affected trafficking routes and crime rates in the Caribbean. The committee expects the Attorney General to address these trends by allocating necessary resources to areas substantially affected by drug-related violence and reporting back to the committee. I wrote this very same week to the President, asking him to direct ONDCP to prepare and publish a Caribbean border counter-narcotics strategy, which would outline a federal plan of action to address drug trafficking and related violence in Puerto Rico and the VI. ONDCP already does this for the southwest border and the northern border. So the first question I have is, do you see any reason why ONDCP should not do the same for the Caribbean border?
I think that's actually a fair point, and it's consistent with what I testified to, I think, before your remarks, my remarks that you referenced before. When one looks at the Caribbean, Puerto Rico in particular, I think we need to have a strategy. We have a task force on Puerto Rico that the Associate Attorney General is one of the co-chairs of. I think to the extent that it is not explicit, that we should develop such a plan.
Thank you. And my second question, and Mr. Chairman, you know, I would like to be able to make my question and then get an answer, even if my time expires. Quite a few of my fellow members have had that courtesy. I hope you can extend it to me as well.
Gentleman just asked the question.
Okay. The second question is, can you explain the concrete steps that DOJ has taken to strengthen its presence in Puerto Rico? Wouldn't it be appropriate for DOJ to increase the resources it devotes to the island, even if it is on only a temporary surge, just as the federal government did when there was a spike in violence on the U.S. side of the southwest border? I know we're living in an environment of constrained resources, but I'm talking about prioritizing the limited resources you have and making sure they're being allocated to the areas where they're needed the most. By the way, and I have the stats, DA has increased its manpower, but the FBI and ATF have not in recent years. Shouldn't you be acting with more of a sense of urgency in this area? Please tell me why I should feel better about this than I do.
Yeah.
The Attorney General will be brief.
Okay. Our law enforcement components have really developed recruitment and retention incentives for agents who are who are stationed in Puerto Rico. Retention is is a unique problem that we have in Puerto Rico, but I think the issue that you raise about surges is something that we are starting to embrace, because we have seen, although we've seen historic drops in the crime rate, we have seen hotspots, for lack of a better term, around the country. And what we are now doing is developing a capacity to surge agents and resources, money at times, to help local law enforcement into those hot spots. We have done it in a couple of cities in the United States, mainland. We plan on looking at other places that we go, and I think Puerto Rico, given the homicide rate, the violent crime rate that is far outstrips what is the national norm, I think Puerto Rico would certainly be a candidate for such a surge.
Thank you so much.
Gentleman's time has expired. The chair recognizes the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. I thank you for your great service to the great state of Texas as a congressman and as a judge. Mr. Attorney General, I want to ask you about a comment attributed to you and then a statement issued by the Department of Justice. In a New York Times interview in December of 2011, you said there is a desire to, quote, get at you because you, quote, consistently take progressive stands. Shortly after that interview, the department issued a statement wherein it said your critics, and I'll quote, your critics rightly view you as a progressive force. The common theme in both of those statements is an apparent belief that you are targeted because you are, to use your term, progressive. So I want to be really clear with you, Mr. Attorney General. I'm not a critic of yours because you consider yourself to be progressive. I'm a critic because I don't think the Attorney General for the United States of America should have any political ideology whatsoever. You are the Attorney General for the entire country, regardless of your political ideology or anyone else's political ideology. You're the Attorney General for everyone. You're a former judge. You're a former U.S. attorney. You're currently the chief law enforcement official for the United States. I don't know what attracted you to the criminal justice system. I haven't had an opportunity to ask you. I can tell you that what attracted me to it was the notion of working solely for a woman who is blindfolded and carries nothing with her except a set of scales and a sword. No political ideology, no agenda, just a set of scales and a sword. And it's important to me that she doesn't care about anyone's station in life, and she doesn't care about their political ideology, and she doesn't care whether they're black, white, brown, progressive, conservative. It's just about the equal application of the law. And further in that interview with the New York Times, you singled out my colleague from South Carolina, Senator Graham, as someone who had good faith in his criticisms towards you. So my question, and then you suggested that others are motivated by something more nefarious. Bad faith, a desire to get at you, a desire to do damage to the president. So my question to you is this: do you think it's possible to be motivated by good faith and still ask who the senior-most level officials within Maine Justice were who knew about the tactic of gun walking prior to Brian Terry's death? Is it possible for me to ask that question and be motivated by good faith?
Sure. I would say that, let's ask, do you think John Ashcroft was a conservative?
I don't know Mr. Ashcroft. I tell you who I do know, Mr. Attorney General. I know the United States Attorney for the District of South Carolina. He was appointed by President Obama. He is every bit as progressive as you say you are, if not more so. And not only have I not been a critic of his, I have been one of his biggest fans, because you cannot tell what his political ideology is from the way he discharges his job. So I don't know John Ashcroft. I don't know you. I know Bill Nettles. I know the United States Attorney. And you can shake your head when I say that, but the truth is, you're the one who said you were being targeted because you're progressive. And my point to you is, I would be asking the exact same questions about Fast and Furious, whether you were John Ashcroft, whether you were Dan Lundgren, whether you were Bob Goodlatte. I don't care about the political ideology of the U.S. Attorney or the Attorney General.
Well, all I would say is this: the decisions that I've made in connection with anything that I've done in the Justice Department don't reflect my political ideology. They reflect my view of the facts, the law, and what my responsibility is as Attorney General of the United States. Now,
well, then why did your department say that? Why did your department in December say that you were a target because you consistently take progressive stands? Do you think that's why I'm asking you about Fast and Furious, because of your political ideology?
I will accept that your question to me is one that is based in good faith. I'm not going to ignore reality and say that all of the attacks that have been directed at me have been those that are non-political in nature or that have come in good faith.
Can I be motivated by good faith?
Reality.
Can I be motivated by good faith and still believe that you ought to have to show an ID to vote in South Carolina, just like you do to have to enter the federal courthouse?
Absolutely. We can have a disagreement. You can operate in good faith and ask that question, as I can disagree with you in good faith and not have a political motivation behind my position.
Well, Mr. Attorney General, you have a difficult job. But if you think that you are being singled out because of political ideology or race or any other characteristic or factor when it comes to Fast and Furious, you are sorely mistaken. I would be asking the exact same questions regardless of what party was in power. And with that, I'll yield back, Mr. Chairman.
The gentleman's time has expired. Chair recognizes the gentlewoman from California, Ms. Chu, for 5 minutes.
Thank you, Mr. Chair. Attorney General Holder, before I begin my questions, I'd like to take a moment to commend you for the progress that the department has made on various issues. For instance, on intellectual property rights, you have made that a priority. It's very, very important for our economy, and I congratulate the Department of Justice on the groundbreaking case earlier this year where you charged 7 individuals and 2 corporations for running an international organized criminal enterprise that was responsible for causing more than $500 million in harm to copyright owners. And I also want to thank the department for seeking to protect every American's right to vote. During 2011, the Civil Rights Division handled 27 new voting rights cases, and with 176 bills introduced in Congress that are aimed at suppressing Americans' right to vote, you're doing incredibly important work. I also want to applaud you for changing the material that the FBI had been using in their counterterrorism materials that had many inflammatory statements about Islam and offensive stereotypes about Muslims. And in fact, the FBI has conducted the review of this counterterrorism training material that indicated factually incorrect information. And earlier, Congressmember Franks said that these were statements that had to do with political correctness. But actually, I wanted to name some of the statements that were made in these training materials that were incorrect and, in fact, offensive. For instance, this one that was in the FBI manual: never attempt to shake hands with an Asian. Or how about never stare at an Asian? I must personally take offense at that, I must tell you. And how about this: the Arabic mind is swayed more by ideas than by fact. Or how about traditional Muslim attire and growing facial hair is an indicator of extremism? I think those are statements that had to be removed from those manuals. And my question has to do with the fact that a generation of FBI agents and Joint Terrorism Task Force members have been trained with these biased materials. What is the department doing to make sure that those that have been trained with those materials don't hold these kinds of stereotypes?
Well, we have certainly removed those materials so that the training does not continue, and as people are updated in their training, we make clear to them that that material was inappropriately shared with them before. There are ongoing things that happen in the field offices to make sure that people don't rely on the kinds of things that you have just read into the record in their enforcement efforts. So it's an ongoing thing. We understand that there have been certain agents who have been exposed to this, and we understand it is our responsibility to make sure that that information, which was incorrect, not politically incorrect, but it was simply factually incorrect, that we make sure that they operate only on the basis of factually correct information.
I truly appreciate that. And actually, I also wanted to talk about another issue, and that's the NYPD and the Muslim community. In August 2011, the Associated Press published an investigative article that described intelligence gathering by the NYPD of the Muslim community in New York. So 34 members of Congress and over 115 community and civil rights groups have requested that the Department of Justice open an investigation on this issue. Has the Department of Justice begun a formal investigation into this issue?
Well, we are aware of the allegations. We have received, as you indicate, several requests to investigate the NYPD, and we are in the process of reviewing these requests. We are very far along in what I will call this preliminary stage, and I expect to be getting something, a formal recommendation, fairly soon.
I would appreciate that, because we want to make sure that innocent Americans aren't spied upon simply for eating at a restaurant or simply practicing their faith, and it is offensive to many. I always remember the fact that we had 120,000 Japanese Americans that were taken off to concentration camps based on allegations of spying, and yet in the end not a single case of espionage was ever proven. So we want to make sure that the rights of innocent Americans is protected.
Okay. Yes, that is our objective as well.
Thank you. I yield back.
Thank you, Ms. True. The gentlewoman from Florida, Ms. Adams, is recognized for questions.
Thank you, Mr. Chairman. Hello, Attorney General. Good to see you again.
Good morning. Good afternoon.
Earlier, when you were asked about when you became aware of the tactics of Fast and Furious, I believe you said it was early part of 2011.
Right.
And how long after Agent Terry's death were you made aware of the fact that one of those guns that walked was actually used to kill your agent?
I think roughly about the same time. I'm not sure we've ever had a ballistic match in that regard, but I think I was made aware of the fact that guns found on the scene were from Fast and Furious, and I think that was about roughly the same time, sometime in February. I'm not sure exactly when.
Would you consider that, because I'm going to go back to your opening statement. You said during your opening statement about how you and your agency are working closely with all the agencies and that all the issues that apply to whether it's the national security leaks, Homeland Security and all of that, you're working very closely, yet you have an agent murdered. There's guns on the scene that come back to Fast and Furious, and it takes 1-2 months before you're made aware of the fact that this has happened?
Well, you're talking about my personal knowledge.
Yes.
There were other people.
You are the Attorney General, are you not?
I will stipulate,
You are our
stipulate
chief.
to that.
You are our
I-
chief
but
law enforcement officer. You
I-
have a dead agent.
No, but I'm saying that there were people in the Justice Department who were aware of the fact that those guns found on the scene were from Operation Fast and Furious. I personally did not become aware of that until February, but there were people in the department working with our DHS allies and people in local law enforcement and the FBI who were aware of that fact. Yes, I thought you were directing the question at just me as opposed to somebody else.
Well, you know, I've listened all day long, and I listened the other day when you were here also, and every time when questions are posed about Fast and Furious, we always get a different timeline or something similar, or we've had a letter called back for inaccuracies months after it was delivered to us. So now we have, you sit here and you tell us today in your opening statement how well your agencies are working together, yet you have an agent who is murdered, and it takes a couple of months before you're made aware as the Attorney General that the weapons that were left and allowed to gun walk were used during his homicide. So I go on to, if we have all of this going on, and I keep hearing you go back to, well, in the previous administration we did this or they did that, you know, I don't really care what happened in the previous administrations. What I care about is the fact that when I worked with agents in the previous administration as a law enforcement officer, I knew that when they went to get a wiretap, they had to produce the evidence of probable cause to their supervisor, who then had to sign off on that. So I listened today, as you said, well, they just signed off on a summary. So are you telling me that your supervisors sign off on wiretaps based on summaries without looking at probable cause?
No, that's not what they do at all. They are satisfied looking at the summaries that are prepared that probable cause does in fact exist, but they do not review these things with an eye towards understanding the full panoply, the full scope of the underlying operation. They only make sure that when we go to court, there is a sufficient basis for us to say that probable cause exists, that with regard to the telephone number that we want to get the wire on, that we can say that that particular phone was involved in the commission of a crime, not the full extent of what Operation Fast and Furious was all about.
So, you know, you've covered a lot of different areas today. I'm still waiting for an answer as to how so many thousands of guns walked. I've never been involved in an undercover operation that would allow such a thing to happen, and it's amazing to me that our own Attorney General's office is the one who allowed it to happen. But then you go in to say that
I did not allow that to happen, and in fact, as
it
soon
was
as I
your
found
agency.
out about it,
You
I
have
heard-
control over that agency, do you not?
As soon as I heard about it, I instructed that that policy, that practice had to stop. I was
After
the
the
first
death
Attorney
of one of
General
our
to
agents.
do that, and I did that.
You also talk about how your agency is working deliberatively on, and there was some information asked about immigration, and then you said, well, you know, we just need a comprehensive solution for immigration issues. Wouldn't that solution be that you and your agency actually enforce the laws on the books that we have today?
We do enforce the laws. We are more effective than any
Well,
administration.
I will
has-
just let you know that when I ask about with criminal aliens that are released back into our
Regular
communities,
order.
because what we have is criminal aliens being released back in our communities because their home countries will not take them back. And I asked, well, do we ever file the 243D paperwork? And I was told no. None during this administration have been attempted. So I have concerns when I ask you about our immigration laws being enforced. The other thing before I go is I will tell you
Gentlewoman's time
this.
has expired.
I'll yield back.
Thank you, Ms. Adams. The gentlewoman from California, Ms. Sanchez, is recognized. I'm sorry. The gentleman from Florida, Mr. Deutsch, is recognized.
I knew it wasn't intentional. Thank you, Mr. Chairman. General Holder, thank you for joining us here today. As we're all aware, General Holder, a statewide purge of suspected ineligible voters is underway in Florida. Now, all voters benefit from voter roll maintenance efforts conducted with oversight, with accuracy, and with enough time to rectify mistakes. Unfortunately, the purge underway in Florida is nothing of the sort. A list of 182,000 suspected non-citizens has been compiled by Governor Scott's administration. This list is so riddled with mistakes that Governor Scott's own Secretary of State, Kurt Browning, objected to the list. Yet the risk was not reason enough for Governor Scott to stop. Cross-checking driver's license data with state voter files was guaranteed to result in mistakes. Guaranteed. Many legal immigrants who have become citizens are still classified as non-citizens in the motor vehicle records. But it doesn't explain how a World War II veteran and Bronze Star winner from Davie, Florida was listed. And it doesn't explain how a Fort Lauderdale small business owner was listed. It doesn't explain the staggering rate of inaccuracy in just the initial stage of the purge. If the rate of inaccuracy in the initial 2,600 holds up for the remaining 180,000, then nearly 40,000 American citizens' voting rights are at risk. And let me be clear about one issue. Everyone here agrees we don't want non-citizens on the roll. I don't, General Holder, you don't. The issue is that this purge will remove thousands of legitimate voters. Why is there zero concern for these voters? Mr. Sensenbrenner earlier called this a model of due process. In fact, the letters going to voters say that they will be removed if they fail to respond within 30 days. The governor believes that a failure to respond to a letter within 30 days is reason enough to lose your right to vote, even if you're a U.S. citizen. Maybe you moved, maybe you don't read your mail, maybe you got lost, or maybe, General Holder, you're a different elderly veteran of World War II who received the letter the week that his wife died and threw it out because he didn't have time to deal with the preposterous assertion that he is not a United States citizen. That happened, Mr. Attorney General. Now, General Holder, I applauded you last Friday for requesting that Florida suspend this error-ridden, unaccountable, and illegal voter purge. The DOJ rightly pointed out that federal voter laws prohibit voter purges within 90 days of an election, thanks to a law passed 2 decades ago. Because the closer you get to an election, the less time you have to correct mistakes. Mistakes like disenfranchising voters. Now, I'm aware the governor responded to you late last night in a letter that showcases his administration's willingness to make up the law as they go along. And I know, Mr. Attorney General, your department will respond in detail in the coming days and will do everything necessary to compel Florida to comply with the law to prevent thousands of Floridians from being disenfranchised. But finally, I want to give you a chance to respond to a letter sent to you yesterday by a colleague of mine. The letter reads that your department's interference in this purge proves that you are, quote, more concerned with protecting the re-election prospects of the president than with upholding justice and enforcing the rule of law, that you are actively working to keep non-citizens who have committed a felony on our state's voter rolls. General Holder, with 16 cases of voter fraud found in Florida, of over 8 million votes cast in 2008, the assertion that voter fraud is an actual electoral strategy is preposterous and offensive, and it's condescending, because voter fraud would be a totally ineffective way to rig an election. It's rare because it's a felony that risks prison time and huge fines, and it's totally illogical way to try to sway an election. You know it is an effective way to sway elections? Scrubbing thousands of legitimate voters off the rolls, eradicating voter registration drives, reducing early voting, and disenfranchising millions of seniors and impoverished Americans who lack government IDs. That's the tactic that Governor Scott and his ilk are using, not just in Florida, but around the country. But maybe I'm wrong, General Holder. Can you just answer quickly, is my Republican colleague right, Mr. Attorney General? Have I missed some grand conspiracy here?
I haven't seen the letter, but that is not what motivated our action or will continue to motivate the actions that we may have to take. I've not seen the response from the governor or the Secretary of State in Florida, but I will assure you that we will make sure that the federal law is enforced and that voter purges happen in a way that is consistent with the law. I share your view that we do not want to have people inappropriately voting, that we don't want to have voter rolls that contain people who should not have the right to vote. At the same time, we should engage in a process that does not put off the rolls people who have served their country as veterans, people who want to exercise that most fundamental of American rights. And so the notion that this is somehow a political ploy is inconsistent. One only has to look at the law, which is clear, 90 days. It is very, very clear, 90 days.
And in fact, General Holder, then, it is possible that as the highest law enforcement officer of the land, that you actually have real concerns about American citizens being disenfranchised, and that the United States Department of Justice, the U.S. Department of Justice, actually cares about protecting the constitutional rights of American citizens that are now being threatened by this illegal voter purge in Florida. Isn't that correct?
That's correct. At base, we have to enforce the law, a law that was designed by this Congress or its predecessor to protect the rights of American citizens. That's what our action is all about, to protect the rights of American citizens.
Thank you. I yield back.
The gentleman yields back his time, and the gentleman from Arizona, Mr. Quayle, is recognized.
Thank you, Mr. Chairman, and thank you for being here, Mr. Attorney General. I want to get back to how the wiretap application is approved and the process that it is. You said that basically whoever it was just reads the summary, determines whether there's probable cause, and if there is probable cause, then they send it off to get approval by the courts. Is that basically what you're saying the process is?
Yeah, line lawyers in the Office of Enforcement Operations look at the affidavits, prepare a summary that's then reviewed by a Deputy Assistant Attorney General, and then it goes to the courts.
So the Deputy Assistant is only looking for probable cause, is that what you're stating?
Right, to make sure there's a probable cause basis.
How is that true? Because under extensive requirements for federal eavesdropping law, the Justice Department officials have a duty to evaluate the law enforcement tactics that have been used in the investigation, why they aren't going to actually make it so that we can have a further investigation, and why you need to have wiretapping put into place. We have Title 18 USC Section 25181C says that the application needs a full and complete statement as to whether or not other investigative procedures have been tried and failed, or why they reasonably appear to be unlikely to succeed if they tried or to be dangerous. Now, we put these sorts of safe measures in place because wiretaps are extraordinarily intrusive. And so probable cause being the only basis for putting the application is just blatantly, it's just false. I mean, unless your Justice Department was not living up to what is actually statutorily required for an application.
But what you're saying is absolutely right, that in fact there is that requirement, and if you look at the affidavits and the summaries, you will see that there is a statement by the person who does the affidavit and the person who prepares the summary that in fact other methods have been tried and have proven to be unsuccessful.
So you're saying that they did know about, see, this is what I'm trying to get at is, did the Deputy U.S. Attorney who actually signed off on these wiretap applications, did they actually go through and understand what the tactics that were being used, since then they would actually know at the time of reviewing those, because you said that all they were looking at were the summaries and looking for probable cause, when actually they would have to be looking for the tactics, why they failed, and why you needed to have eavesdropping going forward. So that would mean that they would probably have that information a lot earlier than when you said earlier.
No, but you're looking at the tactics that were used in order to try to surveil people, all right? That's what you're looking for in terms of these tactics. Doesn't mean that you're looking at every tactic that was used.
It's part of the whole operation, though. But the investigation, for the operation of what they were trying to accomplish, you're using various different tactics. It's not just for surveilling, it's for the whole operation. And so the tactics actually are part of the application, why they failed, why you need eavesdropping. So your deputy attorney actually knew about the tactics, even though you've been saying all along that you didn't because you only had the summary and you were only looking for probable cause.
I've looked at these affidavits, I've looked at these summaries. There's nothing in those affidavits, as I've reviewed them, that indicates that gun walking was allowed. Let's get to the bottom line. And so I didn't see anything in there that would put on notice a person who was reviewing either at the line level or at the Deputy Assistant Attorney General level, you would have knowledge of the fact that these inappropriate tactics were being used.
Are you saying in the summaries or in the whole affidavit?
In the affidavit as well as.
In whole. So there were no comments about the tactics of gun walking within the whole affidavit. Or are you talking about the summaries? Because there's a clear distinction between the two. And if you're saying they're only relying on the summaries and not the whole affidavit, but then you would have to go to, actually, then would it be an untrue affidavit to go get wiretaps if they didn't include the gun walking? So, I mean, is that lying to the court and the tactics that were being used during the operation?
I mean, we have to speak hypothetically here, okay? Because we can't talk about the content.
I understand that, but hypothetically, but so, I mean, I'm just trying to get down to what the process was, because it seems to be a little misleading from what you have said and what Mr. Brewer said in the past, that it was only for legal sufficiency or probable cause in this instance from your perspective, when in actuality the statutes that govern this, especially with federal eavesdropping, are much more strict and require much more proof that federal eavesdropping and wiretapping is necessary to actually go through with it and get the court order to do it.
They do not, these statutes do not require the degree of specificity that you are implying. They do not require you to go and describe all of the things that you have done during the course of an investigation with the degree of specificity that you are implying. That is not accurate.
What degree of specificity do you think that I'm implying here? I mean, you have to go through what the procedures are, what the tactics were. I mean, I'm not trying to say that you need to put down every serial number of a certain shoe that somebody was wearing while they were surveilling somebody, but the basic gun walking is a pretty big piece of the tactical operation in Operation Fast and Furious.
Well, again, I can't get into the contents of the Fast and Furious wiretaps. I am prohibited from doing that under federal law. But I can tell you that the notion that you are pushing, and you're pushing incorrectly, it does not require that degree of specificity, granularity, to appropriately put together an affidavit and a summary that can go to a...
But it provides more than probable cause, which is what you were saying earlier, and it provides more than legal sufficiency, which was what Mr. Brewer was saying earlier.
We'll let him ask the question.
Gentleman's time
my time's expired. Thank you.
has expired. The gentlewoman from California, Ms. Sanchez, is recognized.
Thank you, Mr. Chairman, and General Holder, thank you so much for joining us here today. I know that it's an important responsibility of your office to submit to this committee's oversight, and I know that you would agree that this is an important role for our committee to play. But it can't be easy, I feel your pain, to sit in front of us for such a lengthy period of time and answer questions about the many different areas under your purview. So I'm going to apologize, I come towards the end, if some of my colleagues have already bent your ear on this topic, but I would be remiss if I didn't bring up the recent changes in the Department of Justice policies regarding the reimbursement to local governments under the State Criminal Alien Assistance Program, or known more commonly as SCAP. As I'm sure you're aware, SCAP permits states and localities to seek reimbursements for the cost of detaining deportable immigrants charged with a felony or 2 or more misdemeanors. Deportation is a federal responsibility, and SCAP is a program which acknowledges that our overburdened local law enforcement facilities shouldn't have to bear those costs without some kind of reimbursement or recompense from the federal government, since it is the federal government's responsibility. Shortly after I was first sworn in as a member of Congress, some 10 years ago, local police officials came to me and explained how a change in the SCAP funding rules was having a very profound effect on their budgets. And the 2003 SCAP reinterpretation, in which states only receive reimbursement if a criminal alien is convicted of a felony or 2 misdemeanors, and the arrest and the conviction occur in the same fiscal year, which is an odd and interesting requirement, has had tremendous repercussions throughout the law enforcement community, particularly in my state of California. In California, SCAP reimbursement payments have declined from $220 million in fiscal year 2002, prior to the Department of Justice reinterpretation, down to $112 million in fiscal year 2009. And for 10 years now in Congress, I've been working with colleagues on both sides of the aisle as a bipartisan issue to try to help justice recognize the need to return to the original congressional intent of this legislation. The police departments and sheriff's departments in my state are already having to do more in terms of deterring crime and protecting constituents with less. And this reinterpretation of the SCAP reimbursement really hinders their ability to do that. They're trying under very difficult budget circumstances to do an incredible, and they're doing an incredible job. But they keep asking me, what is the federal government going to do about SCAP reimbursement? And I'd love to be able to tell them that the funds that they desperately need are going to be coming. But last month, I was dismayed to find that your department further reduced the reimbursements under the SCAP program, which has the effect of only further increasing the pressure on local law enforcement and making their jobs that much harder. This change is not only going to would not only reimburse state and local law enforcement if they're holding a known inmate already in ICE's database. And I just want to bring your attention to a letter that I have from the California State Sheriff's Association. And Mr. Chairman, with your permission, I'd like to enter it into the record.
Without objection.
It suggests that if your department had made this change in 2010, it would have reduced payments to California sheriffs by an additional $10 million, and that's already on top of the 50% cut from 2003 to 2009. And I just want to quote a section of this letter, since I think that the California State Sheriff's Association summarizes this issue very accurately. They state, and I'm quoting, "The federal government must uphold its responsibility to the facilities that hold criminal aliens and not allow changes that would weaken the funding provided for SCAP." I hope that you'll give this issue more thought, and much more thought to the impact that this change is going to have on law enforcement communities across the nation, not just to mention Southern California. And I hope that you'll reconsider reconsider this decision and consider rescinding it. I just wanted to make you aware of that issue. I will be following up with your office, and I hope that we can work together to try to ensure that local law enforcement entities will be properly reimbursed for the great job that they do in trying to protect the public safety. And I guess I'll just allow you a brief comment and yield back to the chairman.
Okay, thank you, Ms. Sanchez. The gentleman from Arkansas, Mr. Griffin, is recognized.
Thank you, Mr. Chairman. Thank you, Mr. Attorney General, for being here today. I want to ask you if you're familiar with the Olmstead case that deals with disability law. Are you prepared to speak about that today?
Well, I'm not an expert on it. But
okay. Let me ask you a few questions about it. In my state, we have a number of homes, institutions for the developmentally disabled. And around the country, there have been a number of lawsuits against some of these homes alleging violations of civil rights. And in some instances, these lawsuits are filed with the view that the Olmstead case contemplates a structure where the institutions sort of are phased out, and that individuals who are disabled, intellectually disabled, developmentally disabled, well, those individuals are moved into more community-based care. My state has been, in Arkansas, has been the subject of some of these lawsuits. First of all, I wanted to ask you, do you believe that the Olmstead case requires a movement away from institutional care for the developmentally disabled, or do you believe that these institutions can exist within the Olmstead framework?
As I said, I am not an expert on Olmstead. I am familiar with what the decision talked about, and the unnecessary institutionalization, how that clashes with the ADA. You're asking a question that I think is just beyond my.
Okay. Could I get something in writing on that? And let me continue a little bit. My concern is that those who are implementing, and I understand it's many levels below you, My concern is that some in the Civil Rights Division and the Special Litigation Section at DOJ are pursuing, and to be fair, some of this litigation began in the last administration. So this is an ongoing problem. But my concern is that there are some who read the Olmstead case as, if not requiring a move away from institutional care, at least somehow endorsing the move that those at DOJ some at DOJ have advocated for. And my reading well, I think anyone's reading of the case, the actual case, demonstrates that that's not what the case contemplated. That the case made it clear that that segregation of those with disabilities, it will not be tolerated, but that institutions could be a part of the solution there. And in fact, the opinion, the plurality opinion said, and I want to quote this to you, quote, each disabled person is entitled to treatment in the most integrated setting possible for that person, recognizing on a case-by-case basis that that setting may be an institution. And so that is, if you could get me some answers on that, that'd be very important to me. You know, the lawsuit that was filed in Arkansas was eventually dismissed for lack of evidence presented by the Department of Justice. And unfortunately, it cost the state of Arkansas and the development center that was involved $4.3 million to litigate that. And in the end, it was dismissed for no evidence. And if I won't go into the details here, but I'll just tell you, in a small state like ours, and with an institution like this, $4.3 million was a significant sum of money, and in fact had to be, timber had to be sold, mineral rights had to be sold, et cetera, to help fund this litigation, which was then dismissed because DOJ had no evidence or did not have sufficient evidence. So if you could get me just your views on that, I would very much appreciate it, and I thank you for being here today and listening.
Yeah, I'd be glad to do that. I think that you have the underlying material that you have shared with regard to the disposition of those two cases is accurate. And so what I will endeavor to do is to respond to the questions that you have put to me, and I apologize for not being able to answer based on that correct factual assertion that you've made.
Thank you, sir.
Thank you, Mr. Griffin. The gentleman from Florida, Mr. Ross, is recognized.
Thank you, Mr. Chairman, and Mr. Attorney General, thank you for being here. I guess the benefit of having me question you is I may be the last one. Thank you for your patience today. I want to ask you a couple of questions. The House Committee on Oversight did receive 6 wiretap applications that it reviewed. In that, it's that committee's contention that those applications contain detailed information about Fast and Furious and gun walking. Now, it's my understanding you've reviewed those applications since your last testimony. Is my understanding that you take issue as to what these applications actually detail as to whether Fast and Furious existed or whether there was any gun walking?
Yeah, I mean, you know, what I would do, again, because I can't talk about the contents, I would align myself with the letter that...
Is that James Cole's letter?
No,
or,
the letter that Congressman Cummings set out, I guess, a couple of days or so ago as he went through his analysis of that same material. I think that his perspective is the correct one as opposed to what Chairman Issa
And since then, and my understanding that there was a letter January 27th of this year to Chairman Issa that from Deputy Attorney General James Cole that indicated the changes have been made. 2 of those changes included the Department of Justice has changed its way it responds to congressional inquiries, and it has also changed the internal process for wiretap reviews. In fact, your office has tripled the number of attorneys now reviewing wiretaps. Is that correct?
That's correct.
Is that an indication that what was done before was done inadequately and inappropriately?
No, it was actually in response to office visits that I was making where people were saying it was taking too long for them to make requests in the field and to get them processed in Washington and get the approvals back into the...
So it has nothing to do with another level of review to make sure that as to the accuracy of the content?
One of the changes actually does. When we now require somebody in the field, a supervisor, to look at the affidavit and the application that is sent to Washington, we now require that a supervisor to look at that. That was not a requirement before, and that is to try to make sure that we have better accuracy.
And as I understand it, according to on Tuesday, you have a spokeswoman, Tracy Schmaler, who issued a statement that says the review process for wiretap applications is limited and specific assessment of whether a legal basis exists to support a surveillance request. The review process is not an approval of an operation. I'm sure you agree with that. So the sufficiency of it then has nothing to do with what may be alleged in there. For example, hypothetically, if there was a human trafficking operation going on and the wiretap was being requested for that, at what point do you just not look at the legal sufficiency of whether the requirements are met for the wiretap? At what point do you do something to stop the actual operation that's being asserted in there?
Well, I mean, when you get these affidavits, they are pretty broad-ranging. They describe in pretty good detail what's going on in an operation, but they don't go into all of the, as I was explaining to Mr. Quayle, they don't go into the nitty-gritty of everything that is going on in connection with an investigation. If, for instance, an affidavit did contain, and we're talking totally hypothetically,
right?
If an affidavit did contain some indication that trafficking was going on, that young girls were being, tortured or something, or that guns were being walked. I mean,
Right. What I'm getting at is we now have in place a process in reviewing these wiretap applications that will prevent another Fast and Furious. Is that correct?
I think we do with regard to that supervisory level. This is always assuming that the people who are working on the affidavits are sharing all the information. But it's not. But we shouldn't have that on the basis of just wiretaps. I mean, given the policy pronouncements that I've made and the changes that I've made, I think that is the primary reason why we should not have a repeat of Fast and Furious.
And believe me, I would love to spend more time on that issue. I'm sure you've had enough entertainment on that one. But what I would like to address with you is something that's near and dear to my state of Florida. Is it your opinion that you feel that deceased people should vote?
Obviously not.
And illegal aliens should not vote either?
No, but veterans should be able to.
I couldn't agree more, as long as they're, eligible to vote. But when my state, in furtherance of its obligation to make sure that we have an adequate and sanctified voting process, 9 months ago, request from the Department of Homeland Security, the citizen database, and yet receives not only a no, but no response. And then today, when they're trying to do what's necessary to make sure that the sanctity of the voting process is preserved and appropriate, the Department of Justice stonewalls and said, sorry, you're within 90 days, and therefore the Voting Rights Act applies and you can't do it. So what is my state supposed to do when DHS and DOJ does not cooperate with them in the furtherance of their obligation?
Well, I can't speak to what DHS did, but I will say this about that DHS database. It does not contain people who were born in the United States, so it is not going to be a cure-all, even if...
But why would they refuse to give it? And now they have to go to the motor vehicle rolls to find out, to do their job. I mean, they had better tools with that database than what they have now with their own internal tools.
Well, I mean, I don't know why they didn't, but I can say that the database itself would not be adequate for the kind of purging that is sought by the state of Florida. If it had been...
And there's no reason they should not, DHS should not have, they should have released it to the Department.
I don't know what the basis was for that determination by DHS. I do know that, and I'm concerned about, the numbers of people who I've heard have been inappropriately purged from the voter rolls who are citizens who have voted in the past and who, for whatever reason, got those letters.
Thank you. I yield back.
Thank you, Mr. Ross. Mr. Attorney General, thank you for your testimony today.
Mr. Chairman, have one unanimous consent, please.
The gentleman from Texas, Ms. Jackson, is recognized for unanimous consent.
I thank you. It's a clarification regarding an email sent by Mr. Jason Weinstein. This is his testimony regarding an email referred to by the gentleman from Utah. The email referred to the wide receiver, and the testimony that I'm submitting indicates this statement. When I say it is a tricky case, given the number of guns that have walked, I am talking exclusively about wide receiver. I ask unanimous consent to submit this testimony into the record.
Without objection, the testimony will be made a part of the record. Mr. Attorney General, thank you again for your testimony. Without objection, all members will have 5 legislative days to submit additional written questions to the Attorney General, and we hope he will be timely in his response. This hearing is adjourned.
Thank you.